Did you get the copy of the?
I did.
I have a written one too if you need one.
I've got it and I've reviewed it.
You have an opportunity to review it, you say?
I have.
Okay.
All right, this State of Florida versus Arthur Eugene Uptain, case number 24 CF 3089. My name is Brantley Clark. I am the special magistrate that's assigned to this case today. And we're here today on a motion for a belated appeal. And Mr. Wilson, you've been appointed to represent Mr. Uptain. Mr. Uptain's present in the courtroom. Mr. Frere, you're representing the State Attorney's Office. Is that correct?
That's correct, Your Honor.
And are we ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
And let's see, it's Mr. Uptain's petition. Mr. Wilson, you can call your first witness.
Yeah, for the purpose of the expedition, I talked to my client. I can certainly call him and go through these questions that he's outlined. But we're prepared to rely on the petition itself as our, from an evidentiary standpoint, or I can put him on the record.
Whatever you want to do.
We'll just rely on the petition, Your Honor. I think
Okay.
it establishes essentially that he had made 3 requests according to his sworn testimony, and his allegation is that all 3 of those were ignored or not followed up on.
All right. Mr. Ferrer,
Your Honor, the state calls me. Mr. Joseph Paul.
Mr. Paul, you'll come forward. You can sit in the witness stand. That'd be the easiest thing.
You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do swear.
Thank you.
Mr. Ferrer, you may inquire.
Thank you, Your Honor. Good afternoon, Mr. Paul. Will you state your name for the record, please?
Joseph Derek Paul,
And where do you work now?
with the Wheeler firm
And where were you working in October of 2024?
at the Office of Mark Sims Public Defender
And how long did you work there?
for 1 year.
Hey, do you recognize the petitioner in this case, Mr. Arthur Uptain?
Yes, I did.
Was he one of your assigned cases?
Yes, he was.
Is it your pattern and practice to meet with your clients?
Yes,
Did you meet with the petitioner?
yes,
Do you remember meeting and talking to him during his arraignment for a new charge in October of 2024?
yes, I did.
Did you ever suggest any appealable issues to him in preparation for that arraignment? Did he ever discuss any appealable issues with you?
No,
What was the original offer that had been made to Mr. Uptain in terms of resolving his case?
I believe it was LPS was 111 months.
And what did he end up pleading to?
I think just 5 years.
Did he enter a plea at his arraignment on that day?
Yes,
Was he informed of his right to appeal within 30 days, anything other than an illegal sentence?
yes.
Did he take his plea without reservation to appeal?
He signed the plea that day.
Did you have any other contact with him after that?
I don't remember.
So just to confirm, there was no face-to-face request for an appeal at that hearing?
No.
Right, and you had no contact with him afterwards?
No,
Did you receive any letters from him after that?
I did not.
Did you check with the public defender's office to see if they had received? a
Yes, I
letter?
did.
Did they say that they had received a letter?
They said they had not.
Were you notified afterwards to respond to the petition?
Yes,
And did you do so under oath?
yes.
No, I tender the witness, Your Honor.
Wilson?
Yes. So it's my understanding that you, I'm sorry, I just stand by hand. That you left the office on October 31st of that 2024 year. Is that right? According to the petition or the,
Yes, yes.
okay, does that sound about right?
Yes, I took the week of the 29th off. It was my birthday.
Okay. And you say that after the colloquy, after the sentence, my client didn't say anything to you about an appeal. Okay. Now, what I'm curious about, you just indicated that I wrote it down quickly, you checked with the PD's office. Who'd you check with?
My assistant, Ms. Andrea Cohen,
Okay, so you checked with her. Did you check with someone that was in charge of the office there, say Kim Jewell?
no, I did not.
How about someone like Mark Sims who would be in charge of the entire public defender's
No, I
office?
did not check.
So you checked with an assistant?
I checked with my assistant, yes.
Okay, and she's not in charge of rerouting cases or reassigning cases or any of that?
No.
Okay, and I'm assuming since you never got called by a circuit court judge or by a misdemeanor court judge or anything saying you failed to appear for your hearing. So I'm assuming all of your cases got reassigned.
Yes.
Okay, including Mr. Upton.
I assume so.
But you don't know who it got reassigned to. So you didn't check with the attorney that would have been reassigned to Mr. Upton's case, did you?
It would have been in and Andrea's division.
Well, I understand.
I did not.
You don't know what records they kept. You left the office.
No, I did not.
So the only follow-up you did was a phone call and said, well, we don't see anything here.
Yes.
Paraphrase. When did you do that phone call? I mean, I don't need the date. How far along in this process?
It was the day I got the petition.
And when was that?
I don't know the exact date. It was the same day I filed my answer.
Okay, all right. Nothing further.
Any reiterate?
No, Your Honor.
Can the witness be excused?
Yes.
Yes, sir.
Sure, you may go about your day.
Permission to observe the rest of the.
Yes, sir. Mr. Ferrer?
That's the only witness we have, Your Honor.
All right. Mr. Wilson, any rebuttal?
No, Your Honor, just a oral argument.
Okay. You may go forward.
Yes, Your Honor. What the state has managed to establish is up to around when when Mr. Paul called the PD's office, he hadn't gotten this correspondence on the 22nd and the 31st, but they haven't called anybody from the PD's office. So you have some hearsay about some assistant that looked at a computer and didn't, quote unquote, didn't see anything or whatever he established. This assistant, it's not her job to reassign these cases. And so my defendant's position and my argument is that they failed to establish whether the PD properly reassigned and received and processed my client's request for an appeal. The only thing this witness naturally can say is what he did, but that stops at a certain point, and there's no testimony from that point on if that appeal or request for an appeal was handled properly or handled at all.
Mr. Ferrer?
Your Honor, the state believes in adopting the exhibits in the Attorney General's response. Petitioner has offered no evidence of this conversation that he had. In addition, he's offered no evidence of these letters that were sent. So even though I understand that Mr. Paul didn't receive them, possibly with transitioning employment, the public defender's office has said that there was no record of these letters that they received. I personally confirm that as well, but I understand that's all hearsay at this point, whether or not there was a letter. And again, but there's been no evidence presented by petitioner that these letters were ever sent. And in addition here, the petitioner here received a sentence that was well below his LPS. So, and he did so and accepted a plea without reservation to an appeal anything other than an illegal sentence. And he received a more lenient sentence than was mandated in law at the time. So even for that, he doesn't have any appealable issues or anything that would make it to where he needs to have an appeal.
And I reviewed, I guess, the writ of habeas corpus related to Bill. There was no attachment to that. Is that correct?
That's correct.
No copies of the letter that Mr. Upton is alleged that he wrote. Is that correct?
That's
how I see it, Your Honor. That's why
I haven't been able to find any copies put into the record. So I would disagree that there's no evidence. My client's testimony that he sent it, albeit.
No, I understand that. Yeah, I'm just saying the letters that he's alleged that he sent. There's no copies of the letters. He kept no copies of the letters and attachment to his.
I've been provided none, and there's no exhibits that would be compromised or comprise those letters.
Okay. All right. Anything else?
No, Your Honor.
All right, I know that we're in a time crunch. I'll have a ruling as quick as I can. I'll have the ruling before I run out of jurisdiction. Okay?
Thank you, Your Honor.
And Mr. Upton can be transported back to the Florida Department of Corrections. I believe the minute sheet should suffice for that, Madam Clerk, is that correct?
Yes, Your Honor.
Okay, all right, good luck to you, sir.
Go for it.
Way over there. Yeah, I mean, I'll approach the court on a different matter.
Sure.
I have a misdemeanor plea that was executed.
Man, anytime.
You need to do the whole windup. He likes the windup.
Huh?
The windup.
No, I just want them. I don't want to talk about them. I
He
just.
gets on that every time for,
I actually now advise my
And it-
clients,
and it-
like, if you have any questions, you ask me, because when I say misdemeanor, we got about 8 seconds.
Yeah, that's exactly. And you don't have to do that. You can just, Matt didn't like to do it. Matt likes to have, but I'm not gonna do a colloquy on a misdemeanor. I'm gonna do.
So they're now pre-warned. I said, when I tell this judge misdemeanor, we're done.
That's exactly right. I'm gonna give as much interest as I have in it.
that's my favorite.
Thank y'all. I'll see y'all.
Wednesday morning.
Wednesday morning.
Do you want us here at 8:30 or?
No, unless y'all need to be, I'll be here. But if y'all don't need, if y'all don't.
Your Honor, this is Mr. Dougherty in case 250045, and we're here for a Nelson hearing.
If you'll raise your right hand to be sworn.
solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
All right, sir, state your name.
Jerry Doherty.
Mr. Doherty, what are you asking for today?
Your Honor, I appear before the court to express my serious concerns regarding my current legal representation and the handling of my case. I have repeatedly asked the attorney to file a motion of dismissal based on evidence of 2 individuals involved providing false statements in their police reports. They both are fully aware that my son was 21 at the time. She adamantly said he was 16 over and over to the police to insist that I be arrested. Despite this request, she says she's speaking for you. I don't know if this was something you said or not, that you would refuse to dismiss it, is what I was told. That you would not dismiss it, that it would not change anything, that she lied on the police report. She even just recently, she just did the depositions. And it also turns out that she did lie again under depositions. The Officer Sanders also has spoken to her assistant and knows that she's lied. She's also has a warrant out for her arrest for theft of my property. She stole all my items inside my home, sold them at pawn shops. They have her on video footage. And I've asked Miss Beasley to please explain. She cannot explain to me why this continues. She just shrugs her shoulders and says, okay, it is what it is. It just continues on. And I don't understand, and I can't get her to submit with me in writing why these charges are continuing, why her lying is being admitted and just shunned under the rug when they know this is true. And my son, he was coerced in the lying. On the police report that you have, if you look at his age, you can see it's like, it almost looks like it should be 2003. It looks like it was made into an 8. I've asked to look at the evidence as far as the video footage. And when I went to go review it, it starts off with the police officers behind my couch, lacking context of when they knocked on the door, they said I was under arrest. They come in, begin to question me without reading my Miranda rights.
I'm getting all that. What, Ms. Beasley, what's your response?
Your Honor, I have told him that it's not the matter for a motion to dismiss because he doesn't agree with what the evidence is, or that a witness, he feels that they've lied. That's not something that I can do on a motion to dismiss.
Hush.
He was,
You're not testifying right now.
Again, I've asked for context and I don't receive it when I ask.
I'm getting context right now. I'm the one that she's talking to right now.
he has asked for me to write to him to tell him about his case. It's not typically what I do, so I set up phone appointments for him. They always have the option to come into the office. We've had multiple phone appointments, Your Honor. When he was in jail, I met with him several times. I don't think I've ever shrugged my shoulders and told him it is what it is, but these cases do take a while to resolve. I've tried to explain to him that I can't make the state dismiss the case. I can't make the state give him any particular offer. I can't.
I've heard of that. It is what it is. If a witness is lying, your option is to go to trial. That's the option.
But she couldn't explain that, sir.
That's a jury question, whether she's lying or not, or where he's lying or not.
The police know she lied. Everybody knows
It
she lied.
doesn't matter. That's not a basis for a motion to dismiss.
Why is
That's
one,
not a basis for me to appoint you another attorney. So I'm gonna deny your motion to discharge your
sir,
attorney.
she contacted me at 7:30 in the morning. That's not appropriate either.
Who?
Miss Beasley. 7:30 a.m. is when she
I would
decides to
love
call me.
for if I had an attorney, if they got up then at 7:30 in the morning and contacted me, my gosh, she's at work and she contacted you. So I'm denying your motion to appoint counsel. You can represent yourself or you can go hire an attorney. You're out of custody. That's up to you, but you've got Ms. Beasley. We need to set this for another court date.
Yes, Your Honor, the depositions are
I'm
done.
gonna find that Ms. Beasley is competent in her representation. Just because you don't agree with her is not a
She
reason.
can't answer the questions for review of the
Listen, I'm
third
not arguing
party,
with you
sir.
anymore.
I'm asking my,
Listen, hush. I'm not arguing with you anymore.
I don't want to argue, sir. I just want to ask you one question.
I'm not answering any questions. That's it. We need to set it for trial.
He's set for pretrial July the 15th. I do need for him to listen to those deposition audios that we've got.
Okay.
So I don't know if he wants to come into the office and make an appointment with an investigator to do that. We did have some issues before.
We'll just leave it on that pretrial, July 15th at 1:30. We'll see you then, sir.
See,
Yes, ma'am.
And Judge, the one I have before you this morning is a similar posture to the one Ms. Beasley just had. It's State of Florida versus Joshua Smith. Calm down, Mr. Smith. Your Honor, Mr. Smith has filed a number of pro se pleadings with the court. The problem is he's not representing himself, so the court hasn't been able to address those. He is requesting the court appoint him a fifth lawyer. As you recall, there was a public defender, the Regional Conflict Office, Jonathan Dingus, unfortunately passed away. And now my office, as well as a private investigator, Dan Estes. So I will step aside and allow Mr. Smith to argue why a fifth lawyer should be assigned to the case.
Raise your right hand. Solemnly swear the testimony you're about to give the truth, but the truth so help you God.
Yes, ma'am.
Yeah, you may go forward.
Yes, sir. Thank you, Judge. First, I was like, start out, I believe the lack of attention to his, or to this deficiency in the preparation for depositions and applying the Florida statutes has greatly undermined the future outcome of my trial. The mere fact that my counsel has wrote a letter, which should be attached to the evidence, shows that my counsel hasn't applied the factual evidence from depositions to the body cam footage, as well as him advising me that if I paid an attorney, I could get a good representation and a suppression motion. Shows his lack of commitment to his client, to his particular case. The statement alone depletes the barrier of trust in my counsel. It appears that my counsel is biased towards either me or this particular case in general by the clear ignoring of the facts of evidence. Your Honor, I have asked my attorney multiple times. My wife has copies of emails where she's emailed him for evidence to obtain before depositions so we could do a proper deposition, because to my understanding, there is no CAD calls. And I happen to know these officers were technically out of jurisdiction when they stopped my car. And I asked, can we please get a CAD call so we can contradict the jurisdictional violations and the other problems in the case? We haven't got that. We to my knowledge, it still doesn't exist. There's other things I've asked. We filed a Brady demand back in, I think it was November, and we waited till after depositions to file a compelled motion. So I feel like my due process rights have been violated, because how can you properly prepare for depositions if you don't have the evidence that you want to attack? For instance, we've got the body cams after, or we got the, we got the supposed video of the control buy that was supposedly in the affidavit stated was caught on recording selling a suspected 14 grams of methamphetamines. If you review the control buy footage, it doesn't show me, it doesn't show my vehicle, it doesn't show my voice or anything like that. These are things that could have been addressed in depositions and on a counter argument, especially the traffic stop, because the body cams say they stopped me for this incident. And then in depositions, they change and say, oh, well, we stopped it for this, but there's no factual evidence saying this. And then you said you reviewed my car at the restaurant at 10 p.m., but you pulled me over at 11:32 p.m.
Mr. Saline, your response?
Sure, Your Honor.
And I reviewed the motion and I think placed on, but if you want to go ahead and respond to.
Oh, sure, Your Honor. The discovery, as you may recall, we just had a motion to compel at our last time before you, and Mr. Sullivan stated to the court that we have everything in the case file. In fairness to Mr. Sullivan, sometimes even the state doesn't have everything provided to them by law enforcement. It regularly comes up during depositions. Oh, you didn't get a copy of that report, or, oh, I didn't enter that into whatever. So the discovery items, I think we already addressed at the last court date. The not filing a motion to suppress, that's easy because no one in their right mind would file a motion to suppress when you haven't completed all your depositions. We still have a deposition of former investigator Raymond McNeil. He was scheduled April 22nd and served by the sheriff's office, but did not show up. He's been rescheduled to be deposed in August. There's no one going to trial before deposition occurs. There was a motion to continue the trial filed June the 4th. Trying to think what else was just put together as far as any type of jurisdictional issue. If he read the deposition transcripts, he already knows the answer to that situation. We've acquired everything that's been asked of us, including the file that Mr. Dingus had, which does not contain most of the items that Mr. Smith indicated Mr. Dingus possessed. So, I mean, I'm happy to answer anything else, but quite honestly, Judge, I think you have a couple of things. One, Mr. Sullivan thanks you for giving your trial strategy to him by sharing the letter. But I think you have an individual who wants to represent himself, but wants another bite at the apple for appeal purposes by saying he had an attorney. That's evidenced by all the pleadings that have been filed. I also think that this is difficult when reality sets in. The plea offers the 25 years. Mr. Sullivan's let it be known that he will file pursuit of habitual felony offender and ask you to give basically a life sentence. And so lo and behold, as predicted, a Nelson motion comes forward. So I have no problem if he gets a fifth or sixth or seventh lawyer, as long as the record's clear that, much like the first three, we've done everything that's been asked by the court, including Dan Estes, who's not here, but our private investigator, my God, was there even yesterday morning, despite this motion pending.
Investigator has definitely did his job.
All right, I am going to find that Mr. Saline has done what he's supposed to do, and he's provided competent representation. I'm going to deny your motion for conflict-free counsel. There is a motion to continue the August 4th trial. Does the state have any objection?
Was it just to do the deposition?
Deposition, and then he has
Because
a
if
motion
I-
to suppress. He wants.
If I can get ready to come in before then, can we leave it for that August date?
Yeah, I mean, I'll file the motion to suppress like Anders. v.
Because I'd like to
California
leave it set for
form.
now, for that August trial date, and I'll.
We'll leave it, and we'll set it for July 22nd at 9 o'clock for any motions and trial management.
Okay.
Yes, sir.
I'm fine with, I understand that. There's critical parts in it, like for instance, the CAD call. I would like a copy of the CAD
I
report.
can't, I'm not, that's not up for me. I've already made all the rulings I'm gonna rule, okay? And Mr. Saline's heard what you wanted, okay?
Yes, sir.
All right, we'll see you then.
Thank you, Your Honor. That's all.
Have a good day.
Thank you, Your Honor. We're here today in the state of Ohio versus Justin Spiesman, two different case numbers, first being 25 CR 23 and then 25 CR 566. We are set today for sentencing, and the defendant is present with counsel John Fatika. We were last before you on May 21st. We're on that first case number, the 23 case number. The defendant pled guilty to count 1, possession of drugs, felony of the 5th degree with a forfeiture specification. And also on that same date, on the other case number, pled guilty to count 1, pled guilty by way of information to count 1 to aggravated possession of felony of the 3rd degree, also with a forfeiture specification. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those have since been completed. The defendant has 77 days of jail time credit on the 23 case and 72 days of jail time credit on the 566 case, and there is no agreement as to sentencing. Thank you.
Mr. Fatika?
Good morning, Your Honor. I've had an opportunity to review the PSR and the drug and alcohol evaluation in the case. I'd like to call attention to the fact that while acknowledging that Mr. Spiesman has a prior prison term, that was back in 2015, hasn't had any cases since then, or these are his first cases since then. No history of violence. We'd ask the court to consider the recommendations in the drug and alcohol evaluation. Mr. Spiesman does have some employment prospects. He's got some health issues. There's a mandatory fine on the 566 case. We've submitted an affidavit of indigency. And again, we'd ask for community control sanctions.
Mr. Spiesman, what do you want to tell me?
Sorry, Your Honor, I'm going through some rough times. And it's need an opportunity to change, you know, chance.
It's a story with these pills on that first offense.
I really had no clue how they got there, but they were in my car. I mean,
You don't know how they got there?
I don't know where they came from. The first
Well,
pills.
whose car was it?
It was my car.
Who else drives your car?
I use it to clean out houses and such. That's the only thing I can think of. I clean out like houses that have been foreclosed or whatever, clean out personal property. It's the only thing I could think of on the first ones.
I don't understand that.
I take a lot of stuff to and from boxes, move boxes out of storage units, houses. That kind of work. The empty residentials have been abandoned or vacated.
And you think you took some pills out of one of these houses?
Sometimes you take the boxes that will have like to the pill drops. I don't know, most of them have like there's all sorts of medication, usually heart medication, all that stuff in there that we take to the pill drops. We don't put them in the garbage cans. So it's.
So what pill drop location did you go to where you forgot to drop these pills?
The one in Eastlake.
Where?
It would have been, I think at the police department, or it might have been the one in Euclid.
So somebody left some meth in a house and you just happened to...
The meth was a different story. That was the passenger in my car.
Well, what was that story?
I picked her up and give her a ride, and she, as soon as the car, like my plates were expired, she was in the car. As soon as I turned the corner, the cop was following me. She got nervous and started stashing stuff, swallowing stuff. She put it underneath the passenger seat of my car.
So you weren't doing drugs at all that night or around that time, right?
No, I smoked weed. I do that medically. I smoked with her.
Okay, and the second one?
I thought the methamphetamine was the second one. First one was.
I don't know, you got so many of them, I lose track. So the second one was in April, so what's the story there?
That's what I just told you.
All right, what about the first one then? Let's go back to the first one.
The pill bottle, I have no clue. That car is a work car. And
So you didn't really do anything in either of these cases. So we should just issue an apology and he should take the cuffs off and you should walk out the door. Because you didn't do anything wrong. Is that right?
No,
No? That's not right? Or what? Or no, you didn't do anything wrong?
I possessed them, I guess.
Well,
Yes,
but
I possessed them.
But you didn't know how they got there. It wasn't your pills. The pills must have fallen out of a box that you were going to take somewhere to dispose of. And the other one was the other person's meth. So you didn't really do anything wrong.
And second charge, definitely didn't do nothing wrong. Pills, the first one, pills. I'm sorry, I don't know how they got there.
Okay.
It was my car. Sorry, I've never even heard of the pills.
What are we doing
before.
here? Why don't you dismiss this case, Ms. Bell? Obviously, this guy didn't do anything. If he didn't do anything, then he doesn't need any treatment because he doesn't have a problem. Right? Is that right?
Yes, Your Honor.
Well, let's just give him $10 and a new suit and let him walk out the door. I mean, what the hell? What are we doing here? Can either of the council tell me what the hell we're doing here if he didn't do anything wrong?
Your Honor, Mr. Spiesman did enter guilty pleas to both of the cases.
Maybe he shouldn't have.
And I understand the court's perspective. I do think he could use some help in terms of counseling. I think.
I don't know why though, because he hasn't been in trouble in like 9 years. So he's been. So for some reason, the cops got it in for him and made up all this stuff. Ms. Henley, do you have any input in this? Can you help me out here?
In my interview with Mr. Spiesman, he did tell me that he last used methamphetamine on the date of his arrest, and that he does use the drug by putting it in his coffee to help him calm down and focus. That is why probation gave a recommendation for drug treatment.
Well, where'd you get the meth?
I got it from the person that was in the car.
You didn't know it was in the car. When did you use the
she
meth
had
in
it.
relation to when she got in the car?
Oh, we smoked marijuana with it in there,
With what?
the meth.
Smoke marijuana with the meth? Together?
Yeah.
How do you smoke marijuana and meth together?
I guess it was inside the blunt.
I thought you didn't know that there was any meth in the car.
I didn't know she had that rolled before she got into the car.
She had what?
She had it rolled before she had gotten into the car.
You don't seem to be very honest. Do you or do you not have a drug problem?
I have a drug problem.
Okay. Now we're getting somewhere. So besides this one time with this person smoking marijuana meth in the car, when's the last time before that you used it?
It would have been before I caught the case in December.
Before that?
Before I got my bond, yeah. The first case.
And so you didn't, so what? The first case was in December, right?
Yes, Your Honor.
Okay, so what month did you use it before that?
Before that, it would have been December.
And then you just stopped using for 5 months?
Yes, because I was on
How
bond.
did you manage to do that?
I just quit cold turkey. I mean,
Then why did you start again? Did you think doing meth is good for you?
I got nervous going into this court. I had that court date, paced around. I don't know, I thought it would help.
But you didn't know she had meth until she got in the car.
I didn't know she had all that on her.
I know, but you had no idea she had meth when she got into that car, right?
I don't know.
You don't know.
Yes, I knew she had it.
What good is drug treatment gonna do you?
Help me get out of the funk I'm in. It's been a rough 2 years. I got divorced. I lost my mom unexpectedly. I don't know, I've been depressed. Maybe I need mental help. It's just been a rough 2 years for me. I've been I was doing good when I got out. I started my own business and everything, and then I lost my mother, and then I got divorced. It's just been a downward spiral.
Where do you work?
I do DoorDash. I also do construction. I have a business. But I was currently trying to get into Avery Dennison. My son works there. My father retired from there. I had 2 feet in the door there.
What happened?
I got incarcerated.
Doing what at Avery Dennison?
Working at the plant here in Painesville.
Doing what?
Making specialty tape, running the machine.
Is that when you pick up the second one?
Yeah.
Okay. I've reviewed the pre-sentence report and the evaluation and considered all the applicable statutes and put you on community control for 4 years. On the 23 case, 25023, you're going to serve 122 days in jail with credit for 77. On each of these cases, you'll, the last 30 days, well, on the 566 case, 72 days in jail, 102 days, no, 117 days in jail with credit for 72. Each case, you will complete the jail treatment program and follow all the recommendations. No drugs or alcohol with screens, get a mental health evaluation to follow all the recommendations. Attend at least 4 AA or NA meetings a week and get a sponsor. Full employment, get a valid driver's license. You see only 1 doctor, 1 dentist, and 1 pharmacy for medication. Take it only as is prescribed, sign releases, and pay the cost and supervision fees. Ms. Henley, any other terms?
Your Honor, did you say that JTP should be the last 30 days of the
Yes.
sentence? Thank you.
Yes.
Oh, decision point, Your Honor?
No,
No.
I'll give them the Cliff Note version.
Okay, thank you.
If you see drugs, don't take them. Because if you take them, that's the wrong decision. Not taking them is the right decision. You understand all the terms?
Yes, Your Honor.
If you violate, and I find you violated, you face 12 months on the 23 case, and on the 566 case, 36 months, so a total of 48 months in prison. You understand that?
Yes, Your Honor.
Okay. Now, I hope you can be more honest with yourself than you are with me. Anything else, Mr. Fatika?
We just let the mandatory fine at 566 be waived. Thank you.
Wait.
And Your Honor, just the forfeiture.
Hindi, if no se sabe que te like.
You do the same.
Thank
Court does call the case of the People versus Mbe Ndaye.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good afternoon, Your Honor. Assistant Public Defender Costin Goldbase on behalf of Mr. Bayan Ndaye, who's present to my right. Can you state your full name for the record, please?
Bayan Ndaye.
Your Honor, we're going to be requesting about a month adjournment. There is negotiations going on between the AAG's office and I. My client just needs some time. He is going to be contacting friend of the court to get it, hopefully maybe a readjustment due to a change in circumstances. So we just want to give him time to do that as well as make a payment so he can avail himself of the offer. So we're asking for about a month adjournment, Your Honor.
Any objection from the people?
No objection, Your Honor.
All right.
Okay.
Turn the matter to August 7th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, sir. Court calls case of the People versus Donnell Young Sr.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Young, who's approaching, Judge.
All right, what are we doing?
Your Honor, last time, if the court recalls, this was at exam stage and was adjourned to see if we could resolve it. I have reached out. I've spoken with the Assistant Attorney General. I don't think he's a person who may be able to approve or a deviation from what I think the standard resolution is. I guess we could reset it, but I think it might be more prudent to adjourn this probable cause so I can have a conversation with that person. And I think given the week that it was set, I think that person's on vacation.
Who's on vacation?
I think the Attorney General who was here last time, I believe she's out this week.
I believe Ms. Messer.
Adjourn it to,
Yeah, sorry, Judge, go ahead.
no, it's okay. I'll adjourn it to July 17th, 2025. 9 a.m.
Thank you. I do have a green sheet.
9 a.m.?
Thank you, Judge.
Yes, sir. July 17th.
Very much, Your Honor.
Thank you.
Court calls the case of the people versus Dominic Kelly Payne.
Regardless of the people.
Your Honor, Alexis Pluma, appearing on behalf of Mr. Kelly Payne, who is present over Zoom. Sir, could you just state your full name?
Dominic Kelly Payne.
Thank you. And Your Honor, I do have a green sheet here. We are requesting a 2-week adjournment for plea negotiation purposes.
You guys should be doing these plea negotiations before you get in there, quite frankly. I will adjourn this out July 17th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Montez King.
Good afternoon, Your Honor.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. King, who should be appearing via Zoom.
I'm here.
Mr. King, state your name.
Montez King.
You got him.
Yes, Your Honor. At this time, we'll be requesting a brief adjournment. There's still some potential outstanding discovery from a search warrant from June of last year. The detective whom APA really being reached out to about this is out on vacation this week, should be returning next week. So we just want to make one more confirmation before setting this matter for a preliminary exam.
You don't have an objection to the adjournment, right? Just did indicate to council that the search warrant return could take time. I don't know. I can be back, so I don't want to give the illusion that this.
You're gonna have it.
Yep.
I was gonna ask that question myself. Why don't I?
Yes, that was understood, Your Honor. But just before we set this matter, my client would like to see.
Pardon?
I said that was understood, Your Honor.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Sheldon Lewis.
Can you repeat this for the people? Oh. Please, I retract that statement, sir.
Evan Artery requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of AP. Rachel McDuffie, Your Honor.
Permission to practice is granted.
Evan Artery for the people.
Student Attorney Kara Rosengren on behalf of Mr. Sheldon, Your Honor.
Yes.
Can you state your name for the record?
Yes, Sheldon Lewis.
Sheldon, I didn't bring my whole pants. Lewis. All right,
Yeah.
go ahead.
Your Honor, we're respectfully requesting that the court set this matter for an exam.
Discovery is complete.
Yes, to my knowledge, Your Honor.
People have their witnesses available the 15th.
Try my best, Your Honor.
Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore.
July 15th.
Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Here. Court calls case of the People versus Derek Mark.
Regardless for the people.
Stephanie Cannon on behalf of Mr. Martin, who's appearing to my right. Mr. Martin, could you please state your name for the record?
Eric Martin.
Your Honor, we are going to ask for an adjournment. Maybe you should have. Do you have a green sheet?
Excuse me?
Do you already have the green sheet, Your Honor? There's a green sheet for you, Your Honor, regarding that request for an adjournment.
In her hand.
We're just looking for.
Why is she asking me if I had it? Why, no, you had the thing. Why did you ask me if I had it?
You're right, Your Honor. I don't know what I was thinking. Your Honor, we're just looking for some discovery. The prosecutor's office has let me know that they are working on getting it for me.
Your Honor, it is ready to get picked up at this time. It required a hard disk, so it's now actually ready for it.
Probable cause conference to adjourn July 17, 2020. 9 a.m.
July 17th.
What's that? Bond continued.
I'll call you.
You had a green sheet? Hey, the one I have. No, don't even try it.
She was trying to catch me up with something. Court calls the case, People versus Kaida Matson.
Jennifer Douglas.
Oh, Miss Lowe's here. Hi. Oh, have you? Memorable. All right. You've been quiet over there, just sitting. Okay.
They won't let you do anything?
Really? Why did they say? Hold on a moment. I got it, buddy. Why won't they let you do anything? You're still. Oh, that's. We had to give her a mental health.
Traumatized her, Your Honor. Thank you, Ms. Dano. That makes me feel better. Never mind. I'll quit inquiring.
Good afternoon, Your Honor. Assistant Public Defender Chinazi Kariakin ruling on behalf of, but unfortunately not with, Ms. Kaida Matson.
What happened?
I don't know, Judge. We have not been able to make any contact with Ms. Matson, and we don't have an explanation to the court for her failure to appear today.
Might it be the bond violation?
I thought about that. I did. Very possible, but I don't know, Judge. Yeah.
This is your first case.
It's
spectacular. Good job.
Thank you, Judge.
And or issue for defendant's failure to appear. $25,000 cash surety. That warrant will issue immediately. It already has a no bond. Oh, that's right, because then I'll continue the no bond. Really? Did you really say that? That's what I did? I'm hurt. Court calls the case People versus Kevin McCullough. McCullough, I think is.
Good afternoon, Your Honor. Assistant Public Defender Cosimo Bissi. On behalf. No, my trauma is over. I'm good.
I'm glad it worked out.
On behalf of Mr. McCulloch, but not with Mr. McCulloch, Your Honor. The word I received from him is that he checked himself into rehab this morning.
Pardon?
The word I received from him is that he checked himself into rehab this morning. I still haven't received the proof. I don't know, maybe he's still on the bus on his way there.
Amy Visor on behalf of people who request a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be setting him at up at $10,000 cash.
Yeah, I think he has a no bond from community corrections.
Oh, he's got a CC. Okay.
Yes, sir.
25,000 cash surety.
Thank you, Your Honor.
Probably all of them.
25,000.
Yes. Court calls the case of the People versus Mykesha Malfoy.
Alexis Pluma appearing on behalf of Miss Malcor. And ma'am, could you just state your full name for me?
Mykesha Melcher.
Thank you. And Your Honor, we are requesting an adjournment today. We have just provided the people with some new information that they will need to review to see if we can work out a misdemeanor offer.
Probable cause conference will be adjourned to July 22nd, 2025. 9 a.m.
court. Your Honor, I have court July 22nd in Taylor.
I'll make it the 17th. July
Thank
17th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Thank you.
Thank you, ma'am. Court calls case People versus Vanish Mitchell.
City Attorney Kara Rosengren on behalf of. Ms. Mitchell, could you state your name for the court?
Lanish Mitchell.
Your Honor, we're going to be requesting an adjournment in this matter as we're still awaiting video discovery.
Probable cause July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the People versus Keith Moore.
Andrew Travis, on behalf of people.
Hello?
Hello.
Good morning, Your Honor.
Good afternoon, sir.
And Alex Warren Green on behalf of Mr. Moore. Mr. Moore, can you state your name if you haven't already?
Keith Moore.
Okay.
Keith Jarrett Moore.
Thank you, Mr. Moore. Your Honor, today's date and time for probable cause conference. At this time, I am going to ask the court to set a competency hearing. I have prepared a proposed order.
You're ready for a forensic evaluation.
That is correct, Your Honor.
Forensic evaluation be ordered. I'll set a comp hearing mid-90, please.
Oh, October 2nd.
Set a competency hearing for October 2nd, 2025, 9 a.m.
Yes, Your Honor.
Thank you. Bond will continue. Court calls case People versus Megan Moses.
For the judge.
Christina Vergarian for the people.
Rochelle Feaster, first Assistant Public Defender on behalf of Ms. Moses, who should be on Zoom, Your Honor.
I'm here.
I need a camera, ma'am. Oh, thank you. State your name, please.
Megan Moses.
All right, go ahead.
Thank you, Judge. I did speak to Mr. Ward about the file. He did show me a receipt for about $827 of restitution. Ms. Moses has to pay that in order to have this matter reduced. So we're asking for about 4 weeks. So you can try and get that $827 paid and then resolve this with a misdemeanor resolution.
She paying it?
Yeah. And then I'm going to ask you if we can change the bond to add it as a, so she could pay the court, to make it a bond payable to the court.
Do what?
I don't know what the term is. Isn't it, the court makes it into a bond, and then I believe she can pay you the $827.
Listening to you is causing me trauma.
I apologize, Judge. This is my first case of the day. I'm still.
I know.
I'm still
I
getting
was
more.
fine up until this
No,
point.
sorry, man. It's been a rough day. We apologize.
Defendant, modify your bond. Defendant may pay into court. How much was the
$827.
$827 to be held for restitution?
That's what I was asking for, Judge. Thank you.
I'll adjourn probable cause conference into August 7th.
You understand that, Ms. Moses? Can she hear us?
She's frozen.
She didn't hear any of that.
No.
Ms. Moses? Oh. Oh, she's back. Hello? Were you able to hear any of that, ma'am?
It cut out a little bit. I didn't hear much. Sorry.
All right. You're allowed to pay the $827 into court as bond to be held for payment of the restitution. Okay? You have to pay that at the 14B District Court in Ypsilanti Township.
Okay.
Okay? I'm adjourning your proceeding out to August 7th, 2025 at 9 a.m.
Okay. So do I have to have that fully paid by then, or I guess what is the?
As you spoke to Ms. Carrie really on the phone, we need this paid as soon as possible. So we'd like you to try and get it paid by that date so we can get this matter resolved and closed out for you.
Okay. And then the tether as well, will that be able to be removed?
It will not today.
Okay?
Okay.
Thank you,
All
Judge.
right, thank you.
27.
Court does call the case. People of the state of Michigan versus Rodney Napier.
Yeah, Rachel McDuffie for the people.
Councilman Bilbasi, on behalf of Mr. Napier, but not with Mr. Napier, Your Honor.
Hold for one moment. And what do we do?
Your Honor, I would be asking for an adjournment. I have not had contact with my client. So something needs to be done about these buses, Your Honor. They're causing me trauma.
Bench warrant will issue for defendant's failure to appear. Bond is in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case People versus Nicole Nelson.
Assistant Public Defender Chinazi Kyriakin-Ruli, Your Honor, on behalf of, but unfortunately, not with Mr. Nicole Nelson.
It's two cases.
I know. I know.
Do you have a client on either one?
They just don't like me today. No. They're not the
So this is number two.
Maybe they're number two, Judge.
They might be all on the same bus.
It's possible.
Right.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant will issue immediately.
Keep that.
I almost got stuck in here.
Court calls the case of the People versus Antoine Patterson.
Good afternoon,
Ready, Judge. Portia, please still have Mr. Patterson. Please state your name for the record, sir.
Antoine Patterson.
He
Senior.
apologizing for not having on pants. Mr. Bellinger did not tell him he had to wear pants. So
Oh, yes. Oh my God. Oh my God. Oh, and it's laundry day, I promise. Like, I missed when I was supposed to go to the whole clinic, and I had missed that when it was like 98 outside. and I was supposed to go to her clinic yesterday. Well, I don't remember the day, but we rescheduled it for Monday, and I got like 4 big bags of clothes, and I actually wore these already, and I don't even got my right belt. Like
He,
I made it. I just wanted to
he
make sure
apologizes, Judge, for not
to
having
the,
our
to the
pants.
deepest of depths of my apology. I apologize. Sorry. Oh, sorry.
There's a lot more information I need.
He does have colorful socks, Judge.
What?
He does have nice colorful socks, though.
You picked those out on purpose. No, I'm kidding.
So
I get it.
the court should have 2 things in the file, Your Honor. If the court's willing to do a plea, we have a plea and advice of rights in the form. If it arrived too late, we also have a green sheet for an adjournment, Your Honor. So whatever the court's pleasure.
Why would you be too late in the form?
Okay.
It's not going to be a no contest plea.
No, Judge. All right.
So it'd be pleading, what the plea form indicates is that it's pleading guilty to domestic violence.
Yes.
That being count 2. Count 1, the child abuse, 3rd would be dismissed. There is, the defendant is agreeing, and actually also prosecutor and defendant. Yeah. So it's actually both 3 and 4 that they're agreeing to 7694A, 2 years probation. The offer is contingent on the defendant having no assaultive contact with the minor victim or anyone else since the incident date for the case. Defendant not to have contact with any minor children other than his biological children. Oh, so that's the CPS recommendation. The only part of this that I want to make sure the court's understanding is that I read that to mean that if there is a accusation that comes up that is not known at this point.
Slight benefits, Your Honor. So there has been allegations, and I know both sides have tried very, very diligently to figure out what those are specifically, and you're just not getting enough information. So in the interest of moving this forward, we've adjourned quite a few times. It's contingent on if I receive information or anyone receives information that the victim has been harmed in any way by the defendant since the incident that underlies this case, then that changes everything. We would withdraw the offer, and of course, you know, the plea would then be void essentially, and we'd be back here.
That you're
that is what Mr. Bellinger negotiated. Yes, Judge.
Wow. Okay. I have him to one.
Right hand. Do you solemnly swear to affirm the testimony about to give the true self you got?
Yes.
State your name.
Antoine Patterson Senior.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. Is that correct?
Yes, sir.
That is a misdemeanor punishable after 93 days of jail, $500 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir. Why are they forgetting this?
Oh, this shit.
I just checked.
Oh.
And I want to make sure he understands. So.
Okay. Yes. So he won't be one.
So you understand that while I'm taking your plea, I would not be your sentencing judge in this matter. You understand that, sir?
Yes, sir.
That you would be sentenced before Judge Washington.
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Is it okay to ask a question?
Sure.
Okay, so when you say sentencing and I get to the sentencing court date, the 2-year probation thing and the 4A, that's when I do my probation, I'm off, like just I don't have to try to get it expunged, correct?
Well, I think what he's asking is if he successfully completes his probation under 4A, will this be removed from his record per the statute?
And the probation is what I'm going under. So when I get to the sentence, and he's just going to sentence is it like for a short 2 years probation, or can it be up to 2 years?
the way I read this plea agreement is that you're agreeing to 2 years probation.
Okay, yeah, that's fine with me.
Okay,
Just wanted to clear the BS. I
okay.
still want to plead guilty.
You still want to plead guilty?
Yes, sir.
All right. You have any other questions?
No, sir.
All right, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes,
Is that correct?
I believe so.
Any
Yeah.
question regarding those rights?
No, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to place?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
All right. On the date, did you wish to write or you want me to write?
I will prefer you to, Your Honor.
Okay, no, that's fine. That's fine. I just didn't know in terms of specifics. On July 8th, 2000, between the dates of July 8th, 2024 and July 9th, 2024, at the location of 2871 Binding Drive, apartment 308 in Ypsilanti Township, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of this offense?
I had a lapse of emotions of erratic and made an erratic decision on impulse of high concern.
And what did you do?
I hit a kid and I hit him. I gave him what I feel was a whooping.
Was this child in your household?
Yes, sir.
All right. And so that you had that relationship with the child that you lived together.
Yes.
All right. And I'm a little bit concerned as to you intentionally did the acts to this child that, as you say, constitute a whooping.
Say that. I'm sorry. Say that again, please.
The acts that you did intentionally.
Intentionally. No, I don't want to say like I didn't intend to. You know what I'm saying?
Okay.
Can I help
I'll stop you right there? Because go ahead.
Thank you. What Judge is asking you, I think you had a conversation with Mr. Bellinger before he left, was you had a relationship with this child that lived in the home with you.
Mm-hmm.
And that's a yes?
Yes.
Okay. And you proceeded to hit that child.
Yes.
And you knew what you were doing.
Well, yeah, I mean, pretty much yes. So yes.
Well, pretty much yes, or
yes.
So you knew what you were doing, and you whooped that child, correct?
Yes.
And that could be considered by some, the court, the prosecutor, an excess of what was appropriate.
Yes.
That's a yes?
Yes.
If the court wants to adjourn for Mr. Bellinger to have more conversations?
I think I'm going to. I'm not going to accept his plea. I'm a little bit concerned.
Okay.
Based upon what you said. Pardon?
I'm sorry. I spoke out of turn.
No, go ahead.
Okay, so this has been going on for a while. I'm trying to get the sentence under it because when I went to Michigan Works to try to get into the electrician.
Okay, listen to me, sir. The problem is, and I understand you may be wanting to move this along, the prosecutor wants to move it along, everybody wants to move it along. The difficulty is for me is I have to be assured and convinced that you're voluntarily pleading on this, number one, and that what you are telling me you did would constitute this crime.
Okay.
All right. Because of the way that you answered some of the questions, I'm not saying it's answered wrong. I'm just saying these are my concerns. Because of the way that you answered the questions, also because of some of the things and hesitation that you had in response to questions, I have some concerns as to whether or not you believe that you may be guilty of this offense. And so for your protection, as well as the protection of the plea and the integrity of the plea, I'm going to adjourn this. I'm not going to accept your plea today. I'm going to adjourn this out and allow you to speak with counsel.
Okay.
some additional time. All right?
All right, thank you, sir. I
You're
appreciate
welcome.
it.
And what I will do then is I will adjourn this to the 17th.
Thank you, Judge.
At 9. On continue.
Thank you, Judge.
Court does call the case of the people versus Paris Pope.
Seven Attorney for the people.
Stephanie Cannon, on behalf of Ms. Pope. Ms. Pope, when you're at the lectern, please state your name for the record. Paris Pope. And Your Honor, we would be asking for this to be set for a preliminary exam.
Take it back off, a liar.
Is discovery complete?
No. But Your Honor, it's not discovery that we need for the preliminary exam. I have requested it. I believe they would likely have it to me before the preliminary.
What is it? Because
The best footage. I just don't have the best footage.
the body cam footage?
Yes, that is correct.
Your Honor, if I may, I'm sorry, Kevin. When I looked at this file, I saw that it was a brand new case, and as far as I could see, the other day, we didn't actually have any discovery turned over to the PD's office. If Ms. Cannon has received some of that in part in the last 24 hours or so, that's fine, but I would think.
I have the police report. I have the information. The only thing I don't have is the body cam footage, to my knowledge.
Okay. I'll defer to the court and Ms. Cannon if they're still.
I've let my client know this. My client is asking for a preliminary exam. I've explained to her that the court will not adjourn it for that reason if we don't have it.
Correct.
And she is trying to move forward, Your Honor.
And ma'am, so that you understand, if something appears on that body cam footage that's beneficial to the people and they intend on introducing it, I'm not going to hear any objection from your counsel that you haven't had the opportunity to see it.
Okay.
And adjourn that. You understand that?
Yes.
People have their witnesses available the 15th.
Try, Mr.
July 15th.
Preliminary examination in person, July 15th, 2025, 9 a.m. That's before Judge Washington.
Thank you.
Thank you.
Thank you so much, Your Honor.
Thank you.
Holiday.
Oh, are you leaving us? Are you leaving? No, are you leaving? I mean, you could say you're leaving.
I don't know if I can. Yes.
You can.
Yes.
Well, you have a wonderful holiday.
Thank you so much, Your Honor. Thank you.
I was actually going to express how sad I was that you were leaving us. But I am sworn to tell the truth. What?
I like brisket, just.
You like brisket? Oh, yeah, me too. So I'm keeping mine. Court calls the case of People State of Michigan versus John Riggs.
Zachary Ward on behalf of the people.
And Alex Warren Green on behalf of Mr. Riggs. Mr. Riggs, can you state your name for the court?
John Riggs.
Your Honor, today's date and time for probable cause conference. At this time, we're asking for an adjournment. I've completed a green sheet here. We want Mr. Riggs to speak with a social worker and at least begin a mitigation report. Thank you.
You've seen the community corrections progress report?
I have, Your Honor. I reviewed that with Mr. Riggs. Your Honor, I see that he was late on the June 29th test, at which point he returned an alcohol detection of 0.006. Of course, I reminded him to be on time and, of course, not drink. He is in sobriety court while he's in the felony recovery court. I think he has a strong support system, but as the report reflects, my client does deny consuming alcohol.
Did he take a retest on that?
I'm not sure, Your Honor. I think if this is going to be treated as a violation, I would be asking for a hearing and the long form SoberLink report so that we can see any potential retests. And so we can have that looked at by a PBT expert.
So I'll set a bond by hearing as well as the adjournment of the probable cause conference. Set that out to the 17th, 2025. Danny, actually, that's going to be at a 3 p.m. block because we'll have a bond violation here. Bond will continue at this time.
Thank you, Your Honor, and a probable cause conference at the same time.
Yes.
Thank you.
You'll just be in the 3 o'clock block, and that is in person, and not appear via Zoom.
Got it. Thank you, Judge.
Court does call the case People versus Terrell Stevens.
Mike Gaddy, Assistant Defender on behalf of Mr. Stevens, who is here present by Zoom, Judge.
Yes.
Judge, we'd like to set this matter for an exam.
All discoveries complete.
I reviewed it. It looks complete, Judge.
You will have the witnesses available the 15th. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore in person.
Thank you.
Thank you.
Okay, thank you.
Thank you. Court calls case People versus Colin Vanderbude.
Assistant Public Defender Hannah Appleton on behalf of Mr. Vandermeer, who should be appearing via Zoom from treatment. There he is.
Oh, there he is.
Mr. Vandermeer, will you state your name for the record? Colin Vandermeer. Thank you. Your Honor, I do have a green sheet. We're asking for an adjournment. Mr. Vandermeer is still awaiting treatment at the Forensic Center. He was found incompetent but restorable in November.
Right.
I did send an email to the CFP to see if we could get an update, but I don't have a response.
So he's waiting to get himself enrolled in treatment.
Yes, at the Forensic Center. That was.
Yes, at the hospital. This is a reset of the review. Hearing
Yes.
Is that what it is? Okay. Got remarked. All right. Just bring him back and forth. Why don't I set it for September 25th?
Okay.
And then that way, if we get some updated information, we'll figure it out before then, but we'll just do that. Defendant's bond will continue. Okay,
Your Honor.
thank you, sir.
Mr. Vandermeer, your next court date September 25th. If you have any questions, give our office a call, okay? Okay, sorry. Thank you.
Court calls the case People versus Tyrell Bollocks. Is it Gassara?
Terrell Watch Jacero.
And Assistant Public Defender, not to carry action really, Your Honor, on behalf of Mr. Vox Gassara. Gassara.
Well, we had a client show up.
My
so-
client is here, Judge.
Go ahead.
That's right. Your Honor, we are ready. The people sent over a plea form to us on yesterday. Unfortunately, we weren't able to get everything into the court by the deadline, so we do have a resolution. We're asking for a brief adjournment, whatever the court deems sufficient to review
So-
the document.
Everything you think is resolved
Yes, Judge.
now, but I'll put it over to the 10th,
Okay.
2025. Just put it out a week. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, sir. Is that everything? It is?
So,
2 o'clock, we gotta come back and do this tomorrow?
yes.
Who's gonna be here? Is Lo gonna be here? Oh, she doesn't have any cases. She's traumatized. All right, what? I'm being mean again? Okay. No, you haven't seen me. I can really, never mind. Probably shouldn't say it on the record. Court will stand in recess. All right. Court does call the case People versus Bryn Dalmy, Delorme.
And good afternoon again, Your Honor. Dan Guerin on behalf of Bryn Delormier. Bryn, can you identify yourself, please? She's muted.
Hi, can you hear me?
Yes.
Oh, okay. Hello, Your Honor. This is Bryn Delormier.
Okay. I have before me a plea form. Is that what we're doing?
It is, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired, the 93-day offense. Upon their successful plea, that charge count 1 would be dismissed. That is the court's full understanding of it.
Count 1 and 2.
Yes, counts 1 and 2 will be dismissed. It was further down. Got it.
That's our understanding as well, Your Honor.
All right, very good. Ma'am, could you please, because you usually said you've got one for me. Thank you, sir. Ma'am, could you please raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
My name is Bryn Delormier.
All right, you can put your hand down.
Okay.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, Your Honor.
All right. Court further has to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the Judge Freshour in the 14A3 District Court. You understand that, ma'am?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I'll plead guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor. I have it here in front of me.
All right. Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of April 22nd, 2018, at the location of westbound I-94 in Scioto Township, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed or ingested intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I believe I had a few glasses of wine earlier that evening, but it would have been the previous day, the 21st.
All right. Were you stopped by the police?
Yes, Your Honor.
Or was there an accident?
I was stopped by the police. They introduced themselves as peace officers. There were 2 of them. Yes, Your Honor.
Do you know why they stopped you?
They said failure to stay in my lane.
All right. You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes, Your Honor.
All right. Do you recall what the results of that blood draw were?
They didn't share them with me at the time. I just learned about them recently.
Your Honor, we'll stipulate for the plea, it was a 0.103 blood result.
0.103 blood.
Correct.
All right, thank you. Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle is visibly impaired due to your consumption of alcohol?
I'm sorry, could you restate that, please?
Sure.
Thank you.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
Ma'am, I do have to advise you that if I accept your plea, there is no recommendation or evaluation. But however, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that any evaluation or recommendation, the court would not be bound by. You understand that?
Yes, Your Honor.
And you also understand that if you did that, you would not be permitted to withdraw your plea.
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea to occur?
No, Your Honor.
No, Your Honor.
Has the court complied with the court ruling? Would it be proper to accept this defendant?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will occur
September 22nd, 2025 at 9 a.m.
September 22nd.
Yes.
Okay. September 22nd, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you very much, Your Honor.
Thank you. Thank you, ma'am.
Thank you, Your Honor.
Court calls the case of the people versus Dean Keenan.
Good afternoon, Your Honor. Advisor, on behalf of the people.
Good afternoon, Your Honor. Dan Garrett on behalf of Dean Kuhn.
My name is Dean Kuhn, Your Honor.
Your Honor, I'm asking for an examination on this matter.
All right. All discovery is complete.
I believe it is, Your Honor.
All right. People have their witnesses available to 15.
You said another case with a victim of the case. Could we have the next available date of Mr. Young?
I can't. Can we possible keep it on the 15th? Otherwise, I'm going out pretty far.
The 15th.
Thank you, Ms. Roger.
Preliminary examination, July 15th, 2025, 9 a.m. That is before Judge Washington. It is in person. Bond will, with its conditions, will continue.
Thank you very much, Your Honor.
Court does call the case People versus Jose Montalvo.
Afternoon, Your Honor. Dan Garrett on behalf of Mr. Montalvo. I see him on Zoom. Jose, can you identify yourself?
Jose Montalvo.
Thank you.
Your Honor, he's been accepted into the drug court, so there'll be a straight waiver today.
Okay, straight waiver. Sir, you're waiving your right to a preliminary examination?
Correct, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Do you understand that?
I understand, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Correct, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we'll waive reading of that single count. Stand mute, please.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
September 26, 2020. Oh, August 26, 2025 at 1:30 with Judge Humphrey.
August 26, 2025, 1:30, Judge Cummings. Bond will continue with its conditions. Thank you.
Thank you very much, Your Honor.
Thank you, Your Honor. Is that it for the Garrett? All right.
Nice work, John.
Court does call the case, People versus James Chandler.
Good afternoon, Your Honor. We please this honorable court, Brandon Bird on behalf of James Chandler wearing pants today, Your Honor.
Well, see, we all learn, don't we?
Mr. Chandler, please state your full name for the record.
James Chandler. You promised me you wouldn't come back that way, so you're at. You're it. All right. What are we doing?
Respectfully, we'd like to set this matter for exam, Your Honor.
Your Honor, if I may, I believe that Sandra sent the amended information to the court and defense counsel. I want to make sure.
I have it.
Are understated. I do have that here.
I don't believe I have it.
Today?
Yes, today.
So there's an amended complaint adding.
And Your Honor, it's the change really. It's a domestic violence second offense as opposed to the first offense.
Got it.
So what I can do, counsel indicated to me that he doesn't have it. I can have it printed at the end of the counsel report.
Good. Hold it. I never had so much. Got it. Ms. Tanner, don't worry about it.
I can print another copy.
We'll print another copy and get it to counsel.
Right.
All right. Would you, to the extent that, actually, I don't know that he needs to, but you would acknowledge the second offense notice in the amendment?
I acknowledge the offense notice.
All right. And just so that, well, so she, actually, you waived the reading on count 3. Here's the way, because here's how it had to be done so that we're clear. Counts 1 and 2 existed. They couldn't just add the second offense notice. I guess they could theoretically, but I don't think so. So count 3 is then added as the domestic violence second offense.
Okay, Your Honor, waive the reading stand.
All right. Your client would stand mute, so I'll indicate that he was arraigned on count 3. And so if I set this for exam, is that what you want, sir?
Yes, please, Your Honor.
And so all discovery is complete?
Correct, Your Honor.
All right. And would the people have their witnesses available on the 15th? All right. Preliminary examination in person, July 15th, 2025, 9 a.m. before Judge Moore.
Gonna be here.
Bond will continue with its conditions.
Thank you, Your Honor.
So we'll get that right to you, counsel.
Thank you, counsel.
Thank you. Court does call the case People versus Leorn McEwen.
And for those for the people?
And yes, Your Honor, Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please step to the podium?
Oh, there we go.
State your full name for the record.
Yeah, McEwen. Thank you, sir. What are we doing?
I'd like to.
For an adjournment?
No, Your Honor, we'd like to set this matter for exam.
Okay. Yes, sir. Discovery is complete.
It is, Your Honor.
People have their witnesses available to 15.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 15th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Hang on a second. Is there a file?
You're looking for a report.
I don't have one. Is there one? Hang on a second. I don't know if we have a violation report.
I believe I received that today, Your Honor.
You did? I don't have. Is you knew I was gonna ask you. You're printing it today. Right? Okay. All right. Anything you want to say regarding this violation?
First of all, we'd like to apologize to the court and the prosecution for making representations that my client was clean. I just received a report today and I was going off the indications of my client, in which he apologized to me. And he wants to apologize to this court.
Well, but here's I mean, I understand the apology, but he had, by telling you what he told you, he had you give certain representations to this court.
And believe me, we had a long discussion about that.
I'm sure you did. Okay.
We did. I believe my client maybe was embarrassed. I did, after discussing this with my client indicates to him that he did relapse. The stress of this case was helping him relapse, but he said one thing that really mattered. He said, it's not an excuse. And I understand that my client is taking accountability for this situation.
So he admits to this violation.
He admits to it, Your Honor.
All right, go ahead.
I believe my client takes accountability for this situation. He really came to me and said, I'm really trying to straighten out. He understands that he needs help straightening out. I understand that addiction is more of a disease, and I believe there's better ways that addiction could be handled besides being in the confines of the county jail. My client will take, he is trying to take some conditions serious, Your Honor, but my client suffers from an addiction. He suffers from that disease, and he understands that he needs that help. And he actually indicates to me that he reached out and has been searching for help. He could tell you, I know Domino Farms was one of the places, correct?
Yes, sir.
And he was telling me other aspects, other avenues that he was looking at to get that help. We just asked that this court have leniency, and we're coming to beg your mercy on this matter, and ask that this court have leniency on my client, maybe even allow him in an inpatient treatment, Your Honor, instead of having them behind bars.
Anything from the people?
Your Honor, as the court may remember, yes, last time we were here, we were going to set it for exam, and I had put the offer on the record that it was that if Mr. McEwen provided proof that he had undergone some treatment since the date of this offense, that he offered that misdemeanor, and Mr. McEwen had interrupted and said he'd been in treatment for 5 years. Mr. Bird later, we adjourned, and Mr. Bird later came to me to tell me what the proof was, and while I respect that Mr. McEwen represents that he was for some time clean, I believe that he needs some help from some sort of a program. And so I do not think at this time that he is able to comply with the bond conditions if he's not in a program.
Anything else you want to say?
I respectfully, Honor, I'm asking if there's any way possible that my client, if he does go to jail today, could he be released to some sort of inpatient treatment?
I will always sign an order that allows him to be released to treatment, but what he's not going to do is come before this court, violate our bond conditions, then lie to counsel, have that lie, then go to the court and think that somehow or another he's going to get over on the system. It doesn't work that way, and it certainly doesn't work that way with me. All right, because I know that if his circumstance, if he had told you the truth, Mr. Bird, you would have made sure to try to communicate in some way to this court. Not only just in terms of your ethical obligations, but also just in terms of trying to make sure that the right thing gets done, because that's the way that you are. So I think he's let down a whole lot of people, most of all himself. So at this time, certainly I will entertain anything, but because it'll go before Judge Washington on the 15th, but in the interim, defendant's bond is revoked. He's remanded. Court does call the case of the People versus Adrian Gearman.
Yes, Your Honor. Brandon Bird on behalf of Adrian German, standing in for Hassan Hamadi. Mr. German, can you please state your full name for the record?
Yes, Adrian German. German. All right. And you have no objection to counsel standing in? No, sir. You're standing in for somebody?
Correct.
Yeah. You have no objection to that, sir?
No, no.
Okay, go ahead. All right. You're asking for an adjournment?
Yes, yes, Your Honor.
All right. PCC in this matter will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You and Your Honorable Court have a great day.
You do the same. Court calls case of the People versus Matthew Newton.
Jeremy Glick, Mr. Newton, who's standing to my right. Can you state your full name, please?
Matthew Newton. I have before me a plea form. Is that what we're doing today?
That's correct, Your Honor.
All right. Plea form indicates that the defendant would be pleading guilty to the charge of operating while intoxicated, second offense. That's the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the entirety of the court's understanding of the agreement.
Yes, Your Honor.
Please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Why does everybody state your name?
Matthew Newton.
Thank you. You can put your hand down. Why does everybody think they can wear shorts to court?
I shouldn't have.
What?
I said I shouldn't have. I don't know. I apologize.
You didn't tell him to do that, did you, Glenn?
I did know he was
asked-
wearing shorts. I apologize. I knew he was coming from work. I'm sorry, Your Honor. I will eat that one, but it won't happen again.
How's that sore feel in the middle of your chest falling on that? All right, anyway, all right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to a $1,000 fine plus cost, up to 1 year in jail. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do.
And understanding that, and I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that, sir?
I do.
All right. And understanding that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, did you?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses? Or
Yes.
this offense? February 22nd, 2025, at the location of South Ann Arbor Road near Pleasant Bridge, City of Saline, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 3 or 4 Captain and Cokes over 4 hours or so.
Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
Failure to come to a complete stop at a stop sign.
All right. You're not challenging the right of the police to stop you, are you?
Nope.
All right. Were you ultimately arrested?
Yes.
Were you taken to a hospital for a blood draw? No. You were taken, was there an intoxicator done?
Yes, he was taken to the Saline Police Station where he.
And an intoxicator was done? What were the results of that?
At there is 0.100.
Do you have any reason to dispute those results?
No.
And had you previously been convicted on or about April 4th, 2003 in the 52nd District Court and or on or about May 29th, 2003 in the 48th District Court of operating while intoxicated?
Yes.
All right. I think we got everything there. All right. Is counsel aware of any other threats, inducements, any other inducements, pleas or promises? I'm sorry. Let me do that again. Any other promises, threats, or other inducements that have caused this plea?
No, Your Honor.
None known to the people. I would just make a note for the record that the court did issue a recent order to comply, but no, nothing affecting the plea.
Yes, we issued an order to comply because he had been missing some testing.
Yes, and I've discussed that with Mr. Newton, and he understands the importance of complying. And I will add that he has voluntarily notified probation every time that there has been a late test and tested negative shortly thereafter.
All right. All right. Sir, I do have to advise you, and I don't think there is any sentence agreement or any evaluations that's been done, but if there has been, I would advise you that if you do commit misconduct as defined under the Michigan court rule, that the court would not be bound by any evaluation or sentence agreement. You understand that, sir?
Yes.
And further, you would not be entitled, if you commit that misconduct, to withdraw your plea. You understand that?
Yes.
Now, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 13th, 2025 at 9 a.m. with Judge Freshour in Chelsea.
September 30th, 2025. What time?
9 a.m.
9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court does call the case of the People versus Mark Cochin.
Good afternoon, Your Honor. Amy Meisner on behalf of the people.
And good afternoon, Your Honor. I'm Shannon Smith on behalf of Mark Cochin. Mr. Cochin, can you please state your name for the judge?
Yes, sir. Mark Cochin.
All right. Where we going?
Your Honor, at this time, we're asking the court if we could please adjourn today's PCC. We're asking for a longer adjournment because this is a case involving voluminous discovery. I just received some videos. We need to make sure they work. We discussed August 14th, if this court would allow that. I also have discovery I need to tender to the prosecutor's office because there's a long custody battle and CPS case that goes into the criminal charges in this case.
Gotcha.
One of those.
Yeah.
And no objection to the August 14th date of that. It's acceptable.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Willis Cherry.
David I. Goldstein appearing on behalf of the defendant.
Willis Cherry. Thank you. What are we doing?
Sitting for exam, Your Honor.
And Your Honor, as far as the date goes, would ask if you couldn't set it a little bit further out. The victim on this case is in the military. There was a co-defendant who's already gone to exam, and the victim was able to come on that day. The military was able to accommodate them So I'm asking for a little bit more time so that we can arrange.
So there was already an exam held on the co-defendant.
I believe he ended up waiving, but the day of the exam, the victim was able to come, the military was able to accommodate him. So we're asking for it to be set a little bit out to try to accommodate getting him there.
I'm glad she clarified because it was my understanding he had waived. So when she said he held, I was getting a little surprised.
And I just wanted to know because if it was held that this one would go. I tried to put this before that same judge, but it was not held. So waiver.
Judge, I don't have any objection. I had already looked at the 15th and that was going to be a good day for me, but if she's not available, that's fine.
How long a period in time do you think you need to be able to arrange with the military to have them here?
Give us a month. We'll try to see if we can get it done.
Okay, what about August 12th? Would that work?
Your Honor, I've got two trials in front of Judge Conlon that are scheduled for Monday. One of them I think is going to be a plea, but the other one is probably going to go. I could do the 20th. I'm sorry, the 19th.
Would that work too? I don't have judges for that.
That it is Judge Moore. Judge Moore.
I'm at noon on that. Oh, it's one of those days. Okay. Preliminary examination in this matter will be set on August 19th, 2025 at 9 a.m. before Judge Moore.
Judge Moore, Your Honor?
Yes, sir.
Thank you.
Bond will continue. Court does call the case People versus Antoine Pitts.
David I. Goldstein appearing on behalf of the defendant. Mr. Pitts, there's already a bench warrant for him, Your Honor.
Yeah, there is. He's not here.
No.
Yes, the community corrections bench warrant will continue.
Thank you.
Court does call the case People versus Julius Holst.
Yes. I don't do this for Julius Holst.
Your name, sir?
Julius Holst.
Thank you.
Sorry about that.
Are we doing the plea form?
Yeah, no contest plea. I do have an advice of rights signed from today.
All right. The plea form I have indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing an officer. That is a 1-year misdemeanor. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of any.
That's correct. People, thank you, APA 10.5, and I blame Mr. Goldstein.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name.
I, Julius Holst.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing. That is a misdemeanor punishable by up to 1 year incarceration of $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand what? No, you can put your hand down.
I'm
raising it for me to call on you about.
I'm sorry.
You good?
Yes, sir.
Okay. All right. You also understand, do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. And that is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest. Or guilty.
You're right.
Oh, which one you got?
No contest, I'm sorry.
No contest?
Yes, sir.
All right. You understand that by pleading no contest, you'll not have trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir, no. Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
All right. The court has been handed and has reviewed Ypsilanti Police Department report for their case number 255809. Any objection to the court having reviewed that report?
None from the people.
All right.
No, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea, you understand that if you do commit misconduct as defined under the Michigan court rules prior to the time of your sentencing, that any sentence evaluation or recommendation the judge would not be bound by. You understand that, sir?
Yes, Your Honor.
And you also understand, sir, that you would also not be entitled to withdraw your plea if you commit that misconduct.
Oh, yes, Your Honor.
All
I
right.
didn't understand it.
Is counsel aware of any other promises, threats, or reducements that resulted in this plea?
None from the people, Your Honor.
No, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea? Well, let me put it this way. Based upon a review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Now, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, I believe so, but if I could just confer with counsel for a quick second to make sure that we're both clear on one thing.
Sure.
I just cleared that. I had okay. It was just that thing.
Thank you, Your Honor. I think we're all set.
I believe that people are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be August 25th or August 13th, 2025. Time again?
10 a.m.
10 a.m. before Judge Barr. Bond with its conditions will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case People versus Joseph Tripp.
And Edward Lucas on behalf of Mr. Trim.
How you doing, Your Honor? Joseph Trim.
Thank you.
Your Honor, at this time, I'm asking for an,
Pardon?
if we're asking for an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 15th. Preliminary examination in person will be July 15th, 2025. 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you, sir. Court calls the case People versus Aaron Fromm. Oh, she's here. They're both in Zoom. Okay, counsel, I can't hear a word you're saying.
Is it better now?
Oh, we could say something again.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Yep, we got you now. Okay. All right.
Your Honor, I was going to say that defense counsel brought to my attention that Mr. Fromm actually had a case in Wayne County that covers the same allegations. And so I'll be filing a nolle prosecution.
All right. Any objection to that?
No objection, Your Honor.
All right. This case is dismissed. Once it comes across, I'll sign off on it.
Thank you, Your Honor.
Thank you. Thank you, Mr. Fromm. Court calls case, People versus Richard Whittingham.
Swear to God on behalf of Mr. Whittingham. Mr. Whittingham, would you identify yourself, please?
Hey, Your Honor, I'm Mr. Whittingham.
Okay, what are we doing on this case?
Mr. Whittingham have advised me that he would like to have this case sent over to the district court. I've advised him that he has a statutory right to a preliminary exam and what would have to be done at a preliminary exam. He understands all those features, and with that, he's asking the court to send this case over to the district court.
To the district or circuit court?
Circuit.
All right. Mr. Whittingham, do you understand that you're waiving your right to a preliminary examination?
I agree.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
I agree.
And you understand you won't have that hearing and you'll proceed to circuit court for further resolution?
I agree.
I'll take that as a yes. Counsel?
The people also waive.
Preliminary examination having been waived, defendant is bound over to the court on both counts. Mr. Burkett, you acknowledge receipt of the information, waive its formal reading, and your client stands mute?
That is correct.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 26, 2025 at 1:30 with Judge Krupke.
August 26, 2025, 1:30, Judge Krupke.
Thank you.
Thank you. Bond will continue with its conditions. Court does call the case People versus Anjanae Yancey.
Good. Hello, Your Honor. This is Anjanae Yancey.
Hello.
I don't know if you can see me.
Yes, we can see you.
Okay. Good afternoon, Your Honor. Gabriel Lacey for Miss Yancey.
I can't see you, Lacey. No, I'm kidding. All right. All right, what are we doing in this case?
Your Honor, I don't know if you would be willing to go into a quick breakout room with me and the prosecutor.
Okay, that really causes problems because then I've got to move since you're on Zoom.
Oh, yeah. Okay. I hear what you're saying.
I mean, I can do it. If you think it's that important, I can do it.
I can put it on.
I'd have to pass it because I'd like to get one more case out of the way. But if you think it's necessary, I'll do it.
Okay, I don't mind you passing.
All right.
Thank you, Your Honor.
Pass this case. All right. Thank you. Okay. 3 o'clock is, let's see, that's the comp. Let me do that one. Court does call the case of People versus Charles Hudson.
Good afternoon, Your Honor. Laura Willenbring on behalf of the people.
Good afternoon, Your Honor. Nicole Blank Becker on behalf of my client, Mr. Hudson. He is incarcerated. Is he there on Zoom as well, Your Honor?
Is he in back? Huh?
Is he in custody?
She says he's in custody.
He is in custody.
Really?
His name was never on any of the lists.
His name never, okay.
So,
All right. Folks, hold on. Let me pass the matter. We'll get him up here or on Zoom. They can have him on Zoom. I just need him here when I do this.
okay.
All right. All right. Well, I'm going to go off I'm gonna go off the record, take my conference, come back. By that time, hopefully we'll have him on Zoom. All right, council. Thank you.
Thank you.
Thank you.
Ah.
CNN District Court for County of Western North State of Michigan is now back in session. The hour is 8:17.
You may be seated. All right, put this back in. Let me get this one out of the way. Court does call the case of the people state of Michigan versus Charles Hudson.
Laura Willenbring on behalf of the people.
Oh, you're muted, counsel.
Okay. Good afternoon, Your Honor, again. Nicole Blank Becker, sorry, Judge. It's been a long day. On behalf of my client, Mr. Charles Hudson, who is currently here now via Zoom. Thank you, Your Honor. We're ready to proceed.
All right. Sir, state your name, please.
Charles Hudson, sir.
All right. And counsel's requesting a forensic examination regarding competency. Is that correct?
Yes, Your Honor.
All right. And counsel, I apologize, but I just don't do them by stipulation.
No problem.
Okay. So I have signed the order, and then we'll set a competency hearing date for October 2nd, 2025, 9 a.m. We are, so the council's aware, that's pretty much that period in time. We are getting some back quickly for whatever the reason is. So if it does come back, we will notify the parties and set a hearing date in accord with statute.
Perfect. Thank you, Your Honor.
All right. Thank you.
Have a good holiday, everyone.
All right. Everybody do the same.
Thank you. Judge, do you have the ability to put me in a breakout room with my client?
With him? Yes, I have that ability. Would you like us to do that?
That would be
I
great.
usually don't, but I will.
Because I'm the last one?
No,
Oh, no, there's
because
another one.
because you're my favorite. That's why.
Of
No, I'm
course I am.
All
Thank
right.
you, Judge. I really appreciate
No, we'll make it happen.
Okay,
And
great.
we can
Thank
do
you.
that. All right.
Appreciate you.
There we go. Okay, court does call the case of the people state of Michigan versus Yancey.
That is for the people.
Good afternoon again, Your Honor. April Lacy.
Good afternoon, Your Honor. Andy.
All right. Okay, what we will do in this case, record to reflect we had a bench conference in this matter. Discovery is complete, correct, Ms. Lacy?
Yes, that is correct.
And would the people be able to have their witnesses available on the 22nd?
Sure, Vice Your Honor.
All right. So I will set preliminary examination in this matter in person for July 22nd, 2025, 12 noon before me.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance.
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say This was a very difficult decision to make. I have in front of me allegations of very heinous crimes that caused significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain, is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion. It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoint from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third persons. The court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea agreement, plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone amendment, and the amendment to count 1 may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law and its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remain. The defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser included, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law and the entire criminal justice system. The defendant was not only on probation at the time of these actions, but was also being monitored by the law enforcement and by probation with certain conditions and mandates. The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason, no matter the reason or the excuse. Bears, squirrels, protection from burglars, or zombies makes no difference. The defendant is a convicted felon and has no legal right to possess a firearm for life. He intentionally disregarded that prohibition and spat at the legal system, believing he was above the law and could do what he wanted as he wanted. What happened that day was one of the most serious crimes that could have happened in a situation like this. The only worse outcome would be if the victim had died. Even though the defendant accepts the offered plea deal and admits to guilt, or would admit to guilt, thus eliminating the need for a trial, that is not a decisive factor. The impact on the victim must be viewed as well. The victim in this case is not opposed to a trial. even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim, it is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges rather than the court accepting the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. The state and the defense argue that there is inadequate evidence to prove and support count one as charged. The court is not making that determination. The jury is an impartial and unbiased decision-making body. The jury will determine the credibility and the believability of the facts, testimony, and evidence presented at trial. The state could request of the court permission to amend and file an amended information. If the matter does proceed to trial, should the jury find the defendant not guilty on count one, attempted first-degree intentional homicide as charged, without a lesser included offense presented, the victim must abide by and accept the decision of the jury. Even count one, not part of the equation, there remains 7 additional counts in the information. There is a possibility that the jury could find the defendant guilty beyond a reasonable doubt with the remaining 7 counts, thus increasing the potential sentence exposure to the defendant, leaving the court with a sentence determination. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not received. Mr. Schmidt.
I understand. Thank you.
Mr. Harrington.
Judge, I would request that the court reporter prepare a transcript to expedite the transcript. The court, I also, because this is dean appointment, request that the court authorize me to inquire of appellate counsel for the purposes of interlocutory appeal.
Must do that in writing, and the transcript's going to say pretty much a lot of what is in my written decision, but you'll get both.
I need both. I need it expedited because the time for the request for interlocutory appeal is 10 days, if I recall correctly.
20.
10, 20, doesn't matter. It's a holiday week next week. And then one final question as it relates to interlocutory appeal and the evaluation of that as an option to the defendant. Will the court permit second-degree reckless endangering safety with the firearm to be a lesser included offense to the count one as alleged in the information? If it goes to a jury, do we get to use that as a lesser included offense? Kind of a premature question, but
it could be a premature question, but I may not have been as specific in my statement to the attorneys. The attorneys know the facts better than this court. Attorneys know the facts more in and out than this court, and whether or not, as it relates to intentional homicide, even as an attempt, whether or not the facts would be applicable or they would be able to meet each of the elements of that crime. As I stated, the attorneys have reviewed this. The attorneys have determined that second-degree reckless with the modifier may be a more appropriate charge. The state can always amend the information or can be a part of a different plea agreement, plea deal with other things included. Count one was not the issue for the court.
that raises another issue that I may have to consider for an appeal, but I understand. Thank you, Judge.
we're totally fine going through with the trial with all 7 counts or all 9 counts as they've been charged. And the court is simply saying the jury, the unbiased decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9, they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 through 9.
When's our next status hearing, Judge?
Whenever we set it, we're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
I agree. That's what the law says, Judge.
What are you looking at? How far out?
Do you want to revisit this 17th, 18th of July? You and I will revisit before then, but.
Why don't we talk after this hearing? I think you might have heard things from Judge that she didn't say.
And you're going to get my written decision right here that says everything that I said.
Sure.
Everything I said. All right. So I don't have the ability to do the 17th or the 18th, but.
The next week of the 21st. Status, real short status.
Real short
We'll
status.
either come up with
I can
a new deal or-
probably fit a real short status somewhere in that week that you're asking, but I have to look very carefully because I'm supposed to have a trial, but it is going to be most likely gone and I have other things scheduled. I could do the 17th. I have only a couple hearings scheduled.
what time, Judge?
My one hearing's at 2. How about 1:30?
1:30 works.
1:30 on July 17th. And if you're requesting a transcript, it must be in writing to the court reporter.
Can I send you an email?
All right, anything further?
Not for me.
Mr. Harrington?
Thank you, Judge.
Thank you. We are adjourned.
All right, Tanja, you ready to go? Tanja?
Yes, ready.
Okay, all right. All right, let's go on the record in the matter of the state of Michigan versus Anars Tree Goods, 25662 A and B.
Thank you, Your Honor. Your Honor, Christopher Bogart on behalf of Mr. Einar Trugas, who appears via Zoom. We do consent to hold this hearing by Zoom. Mr. Trugas, can you please state your name for the record?
Name is Einar Trugas.
Okay, and so today's the date for the arraignment pretrial in this matter, and counsel as to the arraignment.
Thank you, Your Honor. We would ask you to waive the formal reading of the charges stand mute. We did have the opportunity to speak to the prosecutor this morning. At this time, we are asking for an adjournment. It's my understanding that the discovery was sent over late last night, so I just need an opportunity to be able to review that with my client, Your Honor.
All right, the court will waive the formal reading. Enter plea of not guilty for purposes of the arraignment. Adjourn this matter. There's no talking in court, please. To July 24th. Does that work for your schedule, counsel?
I believe so. Let me double check real quick. Your Honor, I'm actually in mediation in the morning. Is there another date that we can use?
You want to do the afternoon?
Yeah, that should be able to.
Okay, 2 p.m.
Perfect, Your Honor.
All right, and then as to bond counsel.
Thank you, Your Honor. Your Honor, regarding bond, Mr. Trugas currently resides in Columbus, Ohio. That's the reason why he zoomed in here today. He is currently working as a team massage therapist for the NHL Blue Jackets. He's been recently employed there, so he did have to move down there. He's been in this profession most of his life. He originally worked for the Detroit Red Wings, where he was, I believe during COVID, he was let go during that time, and then he finally got another job doing that. I know he's had some alcohol-related issues in the past. He is currently attending AA. As soon as he moved down to Columbus, he did find other spots where he can go to meetings. From my understanding, he's attending meetings every day. He is in a therapy program. He also does have an ongoing child custody matter with another attorney that's been ongoing, but part of that is for him to be regularly tested. So he is drug and alcohol tested regularly in order for him to be able to continue to see his children. So we are asking the court to take that into consideration. I do recognize that he had an issue with alcohol previously. He is taking steps in order to manage that problem. I do believe him finding this employment, it's a great opportunity, is going to be a real game changer for him and how he handles himself, Your Honor. So we are asking the court to take that into consideration and closing bond here today.
Okay. Well, Mr. Trezewitz, you have been here quite a few times. What happened with the matter that we just had here in January?
Yeah, I was in the court in January, yes.
Yes, no, sir, I understand that. Are you currently on probation for that matter? I don't recall off the top of my head.
Your Honor, still never reduced down to a civil infraction and paid a fine.
Oh, I do recall that. And then here we are now again with another alcohol-related offense. It doesn't seem, sir, that you're learning from rehabilitative conditions and opportunities that you are afforded, sir.
I'm learning from that, and I'm trying to fix my life, and I want to move forward, and I'm doing all best I can do for myself and opportunity.
And Your Honor, with Mr. Treygetz employed with the NHL, I do believe that it will provide him a better opportunity to be surrounded by people of support. Back here, it was really just his wife that was supporting him, and I know he longed to get back into the career that brought him a lot of satisfaction. And I know with this new employment, he does know the owner fairly well. They previously worked together. So I do believe now, I know it seems sudden and strange because he did have another alcohol related offense, but I do believe now in his current position, he'll have a better support system than he did have here, to Your Honor.
But isn't his family here?
His other children are here, so he still sees them, but his custody arrangement doesn't allow him to have those children all of the time. So his custody arrangement had to change with him moving down to Columbus. But Mr. Treygetz recognizes that he has an issue, and everybody agrees that the position that he's in now is the best position for him to afford him to the opportunity to actually work on his recovery.
So here's the concern that, I have serious concerns. He had an OWI for, back in August of 23, and if I recall, it was a fairly high level. And then, that again in January. And then now here we are, and, the allegations in this matter, I think it seems as though, when reviewing the report, it seems as though your client's lucky to even be alive, quite frankly.
Your Honor, I haven't had opportunity to review any of that information, so at this point, the court would know more than me about that. But all of those incidences, Mr. Treygetz was not working. He was sitting at home. He wasn't doing anything. In my opinion, I believe he was severely depressed from when he lost his job during COVID. He finally has an opportunity to get back to doing something that he has great passion for. And I think that's what he was missing when he was just sitting at his house and drinking and getting in trouble. And that's why not only myself, but this team believes in him and brought him aboard knowing that he had these issues in the past. And I do believe that support system is ultimately what's going to help Mr. Treygetz.
All right, so sir, how often are you testing?
I am testing once a week or every other week when I have children or when I don't have children.
Okay. And if you're to test right now, sir, what is in your system?
Absolutely nothing. Hey, ma'am, I test the urine test once or twice every other week, and also I do test for my wife. I do breathalyzer test every time I'm with children, when I'm driving children, or when children spend the night with me. I do the breathalyzer test for her as well, and they're all negative.
Okay. So what the court's going to do is the court is going to, taking all these factors into account, the court's going to order a $10,000 personal bond. Counsel, if you could please update the file or write down your client's current address, so that we don't have to, we're not putting it on the record, but we don't have it, we still have the due one.
Yes, Your Honor.
So, when did your client move down to Columbus?
Your Honor, in April, I believe he was offered the position. They finally signed the agreement, I believe, a couple of weeks ago, and I believe it was Monday last week when he actually reported down there for the team.
Okay.
So he is staying at a temporary house, but it's my understanding that he went down there just so that way he could get down there for employment, but it's my understanding now that he's going to buy either a house or he's going to stay in an apartment or something like that. But he currently is staying in an Airbnb for a week while he was getting down there, Your Honor.
Okay. All right, so the court's going to order you not to possess or consume any alcohol or drugs unless prescribed, and you'll be subjected to radiant testing. Also, sir, so counsel, your client has to be back in person on July 24th. It's not a very long drive, but you need to be in person.
Thank you, Your Honor.
Thank you.
All right, sir. So what that looks like as far as random testing is I'm going to have probation confirm the type of testing that you're doing, sir, and how often that you're doing it, just to make sure it's conforming with everything so that everyone's on the same page, okay?
Perfect, thank you, Your Honor.
And then you'll have to sign some release so that we get those results as well.
Thank you, Your Honor. And should Mr. Trigutz contact probation or probation contact him?
No, he needs to email the probation by 9:45.
And can he have that probation email? Is it 27 probation?
27 DC probation.
I'll send this over to him, Your Honor.
Okay.
And then at the same time when he emails probation, I'll have him email his updated contact information.
Thank you.
That's at wyandotte.gov.
At wyandotte.mi.gov.
Thank you, Your Honor.
Okay, thank you. Have a good day.
You as well, Your Honor.
All right, let's go off the record. Tanja, are you in the waiting room also?
Thank you. Have a nice day, a nice holiday.
You as well.
Thank you.
Tanja, are you in the waiting room?
Yes, Judge. There's a delay for me to respond to you, so yes.
No worries. Okay, thank you. All right.
Okay.
I'm sorry, Miss. Can I log out?
Yes, just make sure you're emailing into probation by 9:45.
Thank you very much. Have a nice
Thank you.
holiday.
Ms. Jesselo?
Yes, Your Honor.
All right, this matter has been adjourned. Notification was sent to the attorneys yesterday. I was unable to review the docket of the recording because our reporter has been out ill for the week. So you will receive a new date, okay?
Okay, thank you.
You're welcome. Have a good day. Okay, Mr. Carmen?
I'm ready, Your Honor.
Okay, Mr. Carmen, are you ready on your matter?
Ready.
Whose phone is that? No, step outside and turn it off.
I did this on myself. Sorry.
Everybody needs to make sure their phones are off. Okay. All right, we are on record in the matter of the state of Michigan versus Caitlin McCabe, 25129.
Good morning, Your Honor.
Good morning.
Elise Lisney, Key 84825, on behalf of Ms. McCabe, who's standing to my left. Ms. McCabe, will you state your full name for the record, please?
Caitlin Grace McCabe.
All right, good morning. And so today's the date scheduled for the adjourned pretrial in this matter. And counsel?
Thank you, Your Honor. We've reached an agreement with the prosecution. My client is prepared to plead this morning to the reduced charge of operating while visibly impaired.
All right. Tom, are you able to hear the attorney?
I hear her, but she can speak closer to the mic will be great.
Okay. All right, and so Ms. McCabe, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. And you heard the plea that your attorney placed on the record, correct?
Correct.
And as to the amended charge of operating while physically impaired by alcohol, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
Counsel, if you can please argue your client.
Thank you, Your Honor. Ms. McCabe, on January 24th, 2025, were you in the city of Wyandotte? Yes. And is that in the county of Wayne, state of Michigan? Yes. And that evening, had you been drinking? Yes. And then did you make the decision to drive? Yes. Were you impaired in your ability to drive by the alcohol you had consumed? Yes. And would someone observing you driving be able to see that you were impaired? Yes. The defense is satisfied, Your Honor.
Okay, counsel, do you stipulate to the .248 for purposes of the plea?
Your Honor, I believe it was .232.
Let's see here. .248, .232.
Yes, Your Honor.
Okay. All right. And so the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss your original charges per the plea agreement, and you will receive a few things from probation. You're going to receive your needs assessment link. You're going to receive the documentation that you need for your pre-sentence interview. You're going to receive your dates for your pre-sentence interview, and then a date to come back for sentencing. Counsel, you can coordinate that date with your calendar as well.
Thank you, Your Honor.
Ma'am, if you're to test right now, what is in your system?
Nothing.
All right, bonding conditions are continued, and how was Maine?
I'm sorry.
Did you go to Maine?
It was beautiful.
Okay, good. All right. Okay, stop over probation. Thank you.
Thank you.
All right. So off the record for a moment, we have the jail here. Okay, thank you. All right. Wayne County Jail or Wyandotte Jail, who do we have there? Dunny or Shameen?
Johnson.
Johnson? Shameen, okay. All right, let's go on the record in the matter of the state of Michigan versus Shameen Johnson, 25974. And counsel?
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf and with my client, Your Honor. She is presently in custody. And today, Your Honor, we're here for arraignment only. I've advised my client of the nature of the charges against her, and she understands them. Thereby, today we waive for arraignment stand view.
All right, ma'am, your name for the record, please.
Jermaine Johnson.
All right, The court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, schedule this matter for pretrial on July 17th at 9:15 a.m. Counsel as to bond.
Your Honor, my client is 37 years old. She supports one minor child, age 4. Your Honor, she's not working presently. She is with her child, and child's being taken care of at this point. Not on probation or parole, nothing else pending. She tells me she's never failed to appear in court, Your Honor. For those reasons, we're asking the court to consider a personal bond. If not a bond, she could reasonably expect a coast. Thank you.
Okay, and so, ma'am,
Yes.
when did you last work, ma'am?
I worked with Instacart and Uber Eats, I'm self-employed.
Okay. And how long were you working there?
I worked about 3 years doing that. I was making between $3,000 and $4,000 a month. I just took some time off. That's it. I could easily go back to it. I plan to. I actually love that work.
Okay, and how do you know Miss Nicole Kova?
I do not.
I didn't hear her, Your Honor.
I think she said she does not.
Oh, okay.
And so, how long have you taken time off, ma'am? How long have you been off?
I have been off since January. My car went down and I just figured I could just take some time off, and it's just, I can go back at any point in time, but I decided that I wasn't ready yet.
All right, well, how are you supporting yourself and your child?
I was receiving gifts and my child's father was helping a lot.
What's your child's father's name?
Kind.
Have you ever failed to appear in court for any reason, ma'am?
No, I have not.
And are you currently on probation or parole anywhere?
No, ma'am.
And how long have you known Mr. Kind?
Mr. Kind, I've known her since 2019.
Okay, so that would be the same person that has been part of the assaultive matters that you've been charged with, correct?
No, that's his nephew.
His nephew?
Bird, I thought that's who we were talking about, as Mr. Kind. If you're talking about Joey Kind, I've only known him for 3 months.
Okay. Given the nature of the charges, the allegations that have been put forth based upon the criminal history of Ms. Johnson, the court is going to order a $5,000 10% bond with the following bond conditions. You're not to have any contact with the complaining witness in this matter. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to her home. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those at your home, ma'am?
No, I do not.
I'm sorry?
I do not.
Okay, and you're not to be released without a GPS tethered through the Wayne County Jail. Any questions? Okay, we'll see you back on the 17th.
Thank you, Your Honor.
Thank you. All right, and let's go off the record for a moment. Do you have Demi Ibarra there?
Yeah.
Okay. Sandra, are you in the waiting room again?
Sorry.
Yes, I am.
Okay. All right, good morning, Wayne County Jail. Okay, that's Ms. Farrell. Good morning. Okay,
That's Ms. Savara, Your Honor.
No, in the Wayne County Jail is Ms.
Oh,
Farrell.
no. I'm talking about
We have 3 different attorneys listed for Ms. Farrell.
Okay,
So I don't know who has Ms. Farrell.
I do not.
Okay, all right. So we are on the record in the matter of the city of Wyandotte versus Demi Ibarra, 25973. And counsel, your appearance, please.
Your Honor, good morning. Richard T. Serrano, P. 33828. Your Honor, today I appear as MNDC counsel for arraignment purposes only on behalf and with my client presently in custody. And today, Your Honor, I've had the opportunity to speak to her regarding all of her rights, signing devices rights, also the nature of the charges against her. She understands both, Your Honor. Thereby, today we waive formal reading, stand mute, ask for a plea of not guilty to be entered in a pretrial to be set.
Okay, ma'am, your name for the record, please. Ma'am, your name for the record, please. Okay, let's try this again, because I didn't hear what you said. Your name for the record, please.
Demi Ibarra.
Okay, and counsel, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on July 16th at 10:45 a.m. And as to bond.
Your Honor, my client tells me that she's single. She supports one minor child, age 6, stays with her. And Your Honor, she's doing part-time work at this point, but not full-time. She's basically, her family is supporting her. She gets some government assistance regarding food stamps and the like. Not on probation or parole. No cases pending, Your Honor, this not being a crime of violence. We ask the court to consider a personal bond.
All right, so ma'am, why aren't you working full-time? Why aren't you working?
I haven't been able to land a job. Can't get any interviews, even though I keep applying. I've been currently trying to finish my GED.
Okay, and so, are you taking classes for that?
Yeah, I paid for the GED Plus program online and I have my book at home. I am only missing my final for science and then the whole course of math, that's it. I finished English and social studies.
Are you currently out on bond in any other jurisdiction?
Sorry?
Are you currently out on bond in any other jurisdiction?
No.
Have you ever failed to appear in court for any reason?
Just for front of the court, one time I had my date wrong in my calendar.
Okay, and,
never been arrested.
okay, if you were to test right now, what is in your system?
Probably weed.
Do you have a prescription for that, ma'am?
No.
All right. The court's going to order a $2,500 10% bond You're not to possess or consume any alcohol or drugs that are not prescribed, including nitrous oxide or any other canister or nitrous oxide canisters. And we'll see you back on the 16th.
Thank you, Your Honor.
Thank you.
All right, thank you. Have a good day. And then we are on the record in the matter of the state of Michigan versus Kaylee Joyce, 25899.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
All right, now please turn your camera on. Thank you. And ma'am, your name for the record, please.
Kaylee Joyce.
All right, today's the date scheduled for the probable cause conference and counsel.
Your Honor, the prosecutor has agreed to reduce this matter to, I believe count 1 is going to be a misdemeanor use and count 2 is going to be a misdemeanor attempt.
Okay, and ma'am, you heard the plea that your attorney placed on record, correct?
Yes.
All right, please raise your right hand. You solemnly swear or affirm the testimony about to give this matter the truth, the whole truth, and nothing but the truth. All right, and you heard the plea that was placed on record, correct?
Yes.
As to the amended charge, count 1 of controlled substance use, how do you plead?
Guilty.
And you have gone over your, I'm sorry, as to the amended charge of attempted possession on count 2, how do you plead?
Guilty.
And you've gone over your rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
I do.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, counsel, if you can please run to your client.
Ms. Joyce, I'm going to take you back to the date of, sorry, let me pull it up. The date of June 24th of this year.
Yes.
Were you in the city of Wyandotte?
Yes.
And were you using a controlled substance, specifically ecstasy?
Yes.
And also on that date, did you attempt to possess another controlled substance, Adderall?
Yes.
And did you have a prescription for either one of those?
No.
I'm satisfied, Your Honor.
All right, and you intended to use the substances that you had?
Yes.
All right, the court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your pleas to the amended charges, dismiss the original charges for the plea agreement, and ma'am, you're going to go over to probation.
Okay.
When you're done here, you're going to receive your pre-sentence interview information. You're going to also receive your pre-sentence interview date as well as a date for sentencing. Okay? And Mr. Carmen, if you'd like to communicate with probation, your client to coordinate with your calendar for sentencing, okay?
Okay, of course.
And ma'am, if you were to test right now, what is in your system?
Marijuana.
Do you have a valid prescription for that?
I do.
And how long have you had that prescription?
About 5 years.
All right, and it's valid?
Yes.
All right, bottom conditions are continued, and please have a seat open probation, and we'll see you back for sentencing.
Thank you.
Thank you, have a good day. All right, so.
Thank you, Your Honor.
I know, well, then the superintendent's boy. And then both probation violation ones should have been changed. So, okay, thank you. Okay. All right, Okay, and Ms. Kavanaugh, I'm sorry, the Wayne County Jail, that's, sir, I just request you to unmute. Can you, do you have the one for Ms. Moss? You have Mr. Shackelford's file? Ms. Moss, do you need to speak to your client?
No, I've spoken with him. We're ready to go, Your Honor. He's going to waive the preliminary examination.
Okay, I'm just waiting for the prosecutor to bring it in,
Okay.
Okay, thank you.
Cyrus next, the other guy. Yeah, he's still got that right.
Oh, that's Mr. Zarek, okay. Okay, Mr. Zarek, your attorney was logged in. He actually logged in quite early, and so he's going to be logging back in just a few moments, okay? Okay, all right, Ms. Kavanaugh, you're here on Mr. Gullickson, correct?
That's correct, Your Honor.
Okay, just remember that.
Young Brandon? You got two friends, huh? First. Yeah. Thank you.
All right, so I don't have the file in front of me, the prosecutor has it right now. Is that one, I know that we were waiting for the report, and your clients aren't being evaluated?
That's correct. My client was in this courtroom and as well as the 36th District Court. Both courts at the same time had originally requested evaluations. In February, I had received an communication from Department of Health and Human Services that he was incompetent to stand trial. So I think we were just now waiting for the time to run on this case, Your Honor, for the Wyandotte case. And that was, I think my calculations, it would be July 14th.
Okay, so I'm going to have you speak with the prosecutor to determine what they're going to do, if they're going to move forward with any petitions or what they're doing. So I just need you to, you'll get pulled, he'll pull you in a breakout room, okay?
No problem, thank you.
Thank you. Okay, the Wayne County Jail, the one that just joined, I'm requesting you to unmute, so can you please unmute?
Hello, Your Honor.
Good morning, your name, please?
Brandon O'Connell.
Okay, it'll be just a moment, a few moments until your attorney arrives. I'm put you in a breakout room.
Okay.
Okay, Mr. Caleb, can you please unmute? And turn on your camera. Okay, Mr. Caleb, why are you on Zoom?
You told me to be on, ma'am. We discussed this on Tuesday. You said we could do this over Zoom.
Okay, that's fine. As possible, I don't have the file right in front of me right now. All right, we're just waiting for your attorney to log in.
Okay, is everything good though? Are we okay?
Oh, yes, it's because your attorney, yes. On Monday, I did have you come in today on Zoom. You're totally
Okay.
fine.
Okay, thank you.
You're welcome. Mr. Carmen, do you have any other matters here? Do you have more matters here?
Your Honor, actually, Wayne County texted me like 10 minutes ago, asking me if I could represent Robert Pacheco. So I was already here and I said, sure. So I'm just waiting for the information on that case.
Okay.
Do you have him on?
I don't know, he should be here in person, I believe.
I have zero info on it, Your Honor. Someone from Wayne County literally texted me at 9:41 p.m. asking if I could do it. I'm like, sure.
He's here in person, right?
Oh, that I don't know.
Mr. Pacheco?
Would needed a spot, no, because they never got back to work.
Okay. Okay, good morning, Ms. Thompson. I will look at, we'll let Mr. Mohammed know that you're on Mr. Pacheco. Actually, if you want to change your name, on your name, if you want to put on the Pacheco instead of Joyce. Mr. Herman,
Okay, that I'm on Pacheco?
on your name, if you rename yourself instead of Joyce, if you throw Pacheco on there, then Mr. Mohammed will see that, okay?
Okay, we'll do. I'm sorry, is he in the courtroom?
Mr. Mohammed is in his office.
No, Mr. Pacheco.
Not yet. I'm not sure if, I don't know if he's checked in yet. Good morning, Terry.
He has not.
Okay. Thank you.
All right, good morning, Ms. Thompson. We're waiting for your attorney, so it'll be just a few minutes, hopefully. Okay, and Mr. Caleb, we're waiting for your attorney. We're waiting for lots of people. Why are we doing this, baby? All right, let's go on the record in the matter of the state of Michigan versus Ryan Gullickson, 231201. Is Mr. Gullickson here? Or,
No, Your Honor, my client's in the Kalamazoo Psychiatric Hospital.
okay. All right, counsel, your appearance for the record, please.
Shirley Kavanaugh, P86281, on behalf of Mr. Ryan Gullickson.
All right, thank you. And I'm sorry, can you have Mr. Mohammed, jump back in the meeting room, please? Yeah. Thank you. I'm just waiting for the prosecutor to jump in the main room so we can handle that one. All right, and Mr. Mohammed, if you can please place your appearance on the record.
Which case is this, Judge?
Gullickson.
I'm sorry?
Gullickson.
Good morning, Your Honor. Mohammed on behalf of the people.
This is the one with Ms. Kavanaugh that you spoke with about, and you're asking.
Oh,
for-
yes.
Okay, so I have you placing your appearance on the record because there's a request for another adjournment, so today's the date scheduled for a review on this matter, and so what's happening today?
Your Honor, we briefly discussed in the breakout room, the time is almost run on my client's case, Your Honor, to establish competency. However, we have about a week or so here until that time has run. So we were just asking to come back to court. My understanding is it would be the 14th, so shortly after the 14th.
All right, and Mr. Mohammed, are the people intending to proceed with any petition as far as you're aware, pursuant to statute?
So there was nothing in our case notes about that I can recall. That's why I would like to speak. We have a specific unit focused on just that, so I'll be reaching out to them today.
Okay, so, okay, well, the 17th would be the date right after the next date right after the 14th.
I'm okay with that date, Your Honor.
Does that work, Mr. Mohammed?
Yeah, any day works for us. I'll be here regardless. And I'm gonna be reaching out to that unit today, so hopefully I'll have an answer by today.
Okay.
If you want to just write.
All right, so we'll adjourn this to July 17th. Ms. Kavanaugh, what time works good for you?
That works for me, Your Honor.
I'm sorry, what time?
Oh, 9:30, Your Honor. 9:30 would be great.
Okay.
Or later.
Okay, we'll see you back then. Thank you.
Thank you, Your Honor. Have a great day.
Okay, let's go. On the record, I'm sorry, let's go off the record for a moment. Do we have the Shackelford file? Because Ms. Moss has been here for a bit and I'm trying to. Ms. Moss, you spoke to the prosecutor and your client and we're ready to proceed.
Yes, I've indicated to the APA that he's waiving, and I've spoken with my client.
Okay. All right. We're just waiting for the file to get in here and then we can handle that matter.
Okay.
All right, good morning, Mr. Harris again. Mr. Harris? Okay, you're driving?
No, I'm not.
Oh.
I'm just sitting still.
You're what?
Sitting still.
Oh, okay, you look as though you're very focused on the road in front of you and with all the lovely bumps in our road, it looked as though your car kept moving, so. Mr. Zarek is present, so I will put the children in the breakout room.
No need to speak to Mr. Zarek, but I do need to speak to the prosecutor.
Okay, all right, so, he will be pulling you in to a breakout room shortly.
Okay.
Okay, and then Mr. Nasser, good morning.
Good morning, Judge. How are you?
I'm okay, how are you?
Very well, thank you.
Okay,
Don't talk in court. Keep talking. You're gonna have to.
all right, it'll be just a few moments until we get to your matter.
Thank
And
you so
we are on the record in the matter of the State of Michigan versus Ryan Joyce, 25709.
Good morning, Judge Deanne Patillo, P 82378, on behalf of Mr. Ryan Joyce. Mr. Joyce, can you state your name for the court?
Ryan Laverne Joyce.
All right, good morning. Again, council, today is the date scheduled for the adjourned probable cause conference. And
we would like
this for an exam.
Correct, Judge.
Oh, okay. My notes showed something a little bit different from the last time, but okay. And so, council, you've already waived time. Does July 24th work?
Yes, that does work, Judge. What time? 11? Does that work for the court?
Yes, we can do July 24th at 11 a.m.
Okay.
Mr. Joyce, if you're in a test right now, what is in your system?
Only my restrictions.
All right, the court's going to also note that any witness and exhibit list by July 21st. Body and conditions are continued.
Thank you, Judge. You have a good weekend.
Thank you, you as well.
Thank
You're
you.
also served.
You said 24th at 10:30, is that what you said?
Yes.
24th.
11 a.m.
11 a.m.
Yes. All right, thank you. Let's go off the record for a moment.
Judge, I'm gonna go check on Shackelford.
Okay, thank you.
Good morning, Judge.
Good morning.
It's Miss Moss. I don't know why that name Shackelford sounds familiar. I don't have any idea.
I was just trying to speak to Ms. Farrell. All right, Ms. Moss, we're just waiting on the file. Ms. Farrell, I'm going to put you in a breakout room, Mr. Serrano.
I'm going to get my client.
Okay, she needs an advice of rights.
Okay, let me see which one Ms. Farrell's in that. 1161. Okay, I think I just Mr. Serrano, right? Yeah. All right. Thank you. You're getting your steps in, aren't you? You want your running shoes today? Okay. Okay, so let's go on the record in the matter of the state of Michigan versus Robert Shackelford, 25858. And counsel?
Yes. Good morning, Your Honor. May it please the Honorable Court, Vanessa Moss, P63901, representing Mr. Robert Shackelford, who appears via Zoom, Your Honor.
All right, thank you. Mr. Shackelford, if you can please state your name for the record.
Robert Shackelford.
All right, and today's the date scheduled for the jury probable cause conference. And counsel?
Yes, Your Honor, I've had the opportunity to speak with my client. We've gone over discovery. My client has decided to make the decision to waive the preliminary examination. He understands that he has a right to hold a preliminary examination where the people have to show that it's more likely than not that a crime was committed by him. And that they have to show that, and that he understands that that is a very low threshold. He also understands that by waiving the preliminary examination, that the matter will be bound over to the Third Circuit Court. And he will also indicate to this court that he is doing this freely and voluntarily, knowing that he has the right to cross-examine the witnesses that the people bring before the court for the purposes of the preliminary examination.
All right, Mr. Shackelford, thank you very much, Ms. Moss. Saved me a whole lot of work having to ask all those questions. So, Mr. Shackelford, you heard everything that your attorney indicated on the record, correct?
Correct.
All right, and the court will then note that defendant having waived his right to preliminary examination, defendant come to circuit court for further proceedings. You are to appear in circuit court on July 10th. At 9 a.m. Counsel, any objection to the court indicating via Zoom on both your signature line and your client's signature line? Counsel?
Thank you.
Do you have any objection to this court indicating via Zoom on both your signature line and your client's signature line?
That's fine, Your Honor.
Okay. All right. You are to appear in circuit court July 10th at 9 a.m. on the charges in the complaint warrant and bond and conditional interview.
Your Honor, I believe my client has indicated that his mother is there, ready, willing, and able to pay the bond, but there is a hold on my client at Wayne County. So he understands that, and we will address the bond when we get down to Third Circuit Court.
All right, yes, and there's currently a $25,000 10% fine, as well as additional conditions regarding possession and use. And and I believe also a tether based upon Mr. Shackelford's continued absconding from court. So that would be a GPS tether, and he can be tethered to the Wayne County Jail. And I believe that that's the court order, so that may be why there's a hold. All right, thank you.
Thank you, Your Honor. Have a good weekend.
Thank you, you as well. Have a good day, Mr. Shackelford.
Thank you, Your Honor.
Okay, and we are on the record in the matter of the state of Michigan versus Brandon Zarek, 25820. Mr. Harris, good morning.
Your Honor, Wyatt Harris, P54891 on behalf of Brandon Zarek, who I think just left the room at the jail.
No, I don't think so. No, Mr. Zarek? Mr. Zarek, can you please unmute? Hold on. Let's go off the record for a moment. No, that was Mr. Shackelford that just left the room. Okay.
No, I think this is Mr. Zarek coming back, Your Honor.
Okay. That's Mr. Zarek, for sure. Who's this individual that told me, somebody told me that was Mr. Zarek? Okay. The individual that I'm requesting to unmute, I'm pushing the button. Please hit unmute in the Wayne County Jail. No, not you, Mr. Zarek. I see you. Just one moment. The individual that has short hair, sir, please hit unmute. Good morning. What is your name, please?
Justin Carlton.
Okay, somebody told me that that was Mr. Zarek, which I didn't think was accurate, but I thought maybe you got to hear it. Okay. All right, so it'll be just a few moments and somebody will be with you shortly. Okay, all right, and Mr. Harris, can you speak to your client at all or no?
No, I do not. Mr. Zarek is the gentleman that was brushing his hair.
Yes, no, Mr. Zarek's familiar to this court. He's been here a number of times, so.
I thought so.
Let's go on the record in the matter of the state of Michigan versus Brandon Zarek, 25820.
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of Brandon Zarek. Mr. Zarek, give your name for the record.
Brandon Zarek.
All right, and so, good morning. And today's date scheduled for the adjourned probable cause conference in council.
Your Honor, I've spoken to Mr. Zarek about his rights to a preliminary examination. He understands those rights, however, he wishes to waive those rights. And I present Mr. Zarek to you for voir dire.
All right. And Mr. Zarek, your name for the record, please.
Brandon Zarek.
And you have heard the, I'm sorry, let me just clarify here. You understand, sir, that you do have the right to have a preliminary examination, must be shown that a crime was committed and probable cause exists to charge you with that crime.
Yes, ma'am.
You also understand, sir, that by waiving your right to a preliminary examination, you will be found over circuit court on the charges of the complaint warrant, correct?
Yes, ma'am.
And you've received notice of those charges, is that also correct?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to a preliminary examination?
No.
All right, the court will note examination having been waived, defendant found over to circuit court or further proceedings to appear in circuit court on July 10th at 9 o'clock in the morning. And counsel, do you have any objection to this court indicating via Zoom for both you and your client?
No, what was the date for the arraignment, Your Honor?
July 10th, counsel.
July 10th, okay, thank you.
You're welcome. All right, the court will note bonding conditions are continued. Is there anything else?
Nothing further.
Okay. All right.
Have a good weekend.
Thank you. Have a good weekend. All right, and we are on the record in the matter of the state of Michigan versus Alexandria Bryant 25272.
Your Honor, Bill Columbus, P3434, on behalf of the defendant. Could you please identify yourself, your name on the record?
Alexandria Bryant.
All right, thank you, and good morning. And today's date scheduled for the arraignment pretrial in this matter, and counsel as to the arraignment.
We stand mute to wait formal reading of the citation of complaint in the matter.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment and as to the pretrial.
Your Honor, that I talked to the prosecutor, and if we could have July 24th as the final pretrial in the matter for the videotapes. And there's a discovery order, I think, before the court. I have the police reports, just need the videos.
Right, the court has had the order regarding discovery, and the court will adjourn this matter to July 24th at.
Your Honor, I have at 10 a.m. I mean, I'd like to keep the 24th, I agree. At 10 a.m. I have a sentencing in 33rd District Court with Judge Henson. So, you know, can we do 11? Or you want to leave it at 10 and I just run like?
We could do 8:30.
That sounds wonderful.
We can do 8:30.
That sounds wonderful. Just so I'm not in contempt by not being there at 10.
I don't hold individuals in contempt for not being here right on time because I understand things occur.
They know me well. Thank you, Judge.
And as to bond.
Oh, Your Honor, my client has no criminal history. She's 29 years of age. She works full-time. She lives with her parents. She's saving for a home. And she works on Grosio. And respectfully request a personal bond. Thank you.
All right, ma'am, where is it you work?
Tipsy Fish on Grosio.
And if you were to test today, what would be detected in your system?
Just marijuana.
Do you have a valid prescription for that or a medical letter from your doctor?
Yes.
You do? Which one?
I have a medical card.
Okay, and it's valid?
Mm-hmm.
Yes?
Yes.
Okay. And have you ever failed to appear in court for any reason?
No, Your Honor.
You're not on probation or parole anywhere?
No.
Are you out on bond in any other jurisdiction?
No.
All right, the court's going to continue your cash bond.
Thank you.
Not to possess or consume any alcohol or drugs that are not prescribed. Please have a seat. You'll get a copy of your bond conditions. The counsel will get a copy of your discovery order. Have a good weekend.
Thank you. You have a good 4th too, Judge.
Thank you. All right, let's go off the record for a moment.
Excuse me, ma'am.
I don't feel like things are coming soon.
I'm sorry, Judge. I thought everything was set.
I'm not saying you guys aren't getting it, but I'm just.
Your Honor?
Yes.
Before you, may I approach?
Okay.
Seem to go a little bit confused.
Okay, Mr. Cavalieri, good morning.
Good morning.
All right, can you please turn on your camera?
I'm just observing today, Your Honor.
Oh, okay. All right, and then I have the Attorney McGuffey.
Yes, good morning.
Good morning. All right. I'm waiting for Ms. Thompson's attorney. Have you spoken with Ms. Thompson's attorney?
I have not. We did email earlier this week. I can reach out to him now, Judge.
Okay, I mean, it's not scheduled till 10:30, so I'm just letting you know what we're waiting for. Okay. And then, oh, there he is. He's here. Okay, and then Mr. Gregory, I have the Tomlinson file back, so we can handle that in just one moment here. Okay.
Sorry, Your Honor.
No, you're okay, you're okay. I just need you to not be walking around when I call the case. Good morning, Mr. Mawad.
Good morning, Judge. Hi, Kelly.
All right, counsel, do you need a breakout room?
No, I just talked to the client, Judge. There's so much discovery. We're going to waive the exam. I think it's better off if Kelly's okay with that. From the AG's office, we're going to waive.
Hold on, please, hold on. I just asked the question about that. I just was going to call the counsel before I call you. Now you need to have your suit jacket on, please.
Okay.
Okay, I have to find out if we have to get approved from the regional office for the court to order an attorney to continue on the case. So, all right, let's go on the record in the matter of the state of Michigan versus Jake Tomlinson, 25804.
Good morning, Your Honor. Austin Gregory, PA 5193, on behalf of Mr. Tomlinson. Mr. Tomlinson, please state your name for the record.
Good morning. This is Jake Tomlinson, Your Honor.
Good morning, and thank you for dressing appropriately, at least on the top half, I don't know, but thank you for dressing appropriately for court. Counsel, today's the date scheduled for the probable cause conference, and your
and Your Honor, with that, we have received discovery. Would ask for an in-person preliminary exam.
all right, and counsel, are you waiving time?
One second, Your Honor.
You should have June 20th. You waive time on June 20th. All right. We could do an exam on. We could do an exam on July 24th.
So I'm not going to be in town on the 24th, Your Honor. Are there dates available in the 2 Thursdays preceding it?
July 17th, we can do at 9 a.m.
We can do that, Your Honor.
All right,
Your Honor.
July 17th. Yes, sir?
Yeah, that works for me too.
Okay. All right, July 17th at 9 a.m. Any witness and exhibit list by July 14th.
Thank you, Your Honor.
Thank you. Bonding conditions are continued. Have a good weekend.
You too. You have a great.
You all have a wonderful day.
You as well. All right.
Okay.
Okay. All right. I'm not sure whose SC's phone is. Okay, SC's phone that just logged in, please unmute. And tell me your name.
Amanda Beckington.
I'm sorry?
Amanda Beckington.
You're here from Mr. Pacheco, correct?
Yes.
Okay. All right. Okay, I'm just gonna have you stay muted and have your camera off. Thank you. Okay. All right, let's go on the record. Okay, let's go on the record. Is you that Jennifer Coleman or Cunningham?
Yes.
All right. In matter of the state of Michigan versus Jennifer Cunningham, 25627. And counsel, your appearance, please.
Your Honor, John Goldfloss, 30758, Your Honor, on behalf of Ms. Cunningham. Ms. Cunningham, please put your name on the record.
Jennifer Lynn Cunningham.
All right, and so thank you. And so today's the date scheduled for the adjourned date, and Mr. Goldfall was to follow the matter, which he did. However, there's apparently a process that the court has not been made aware of by the region office for appointing attorneys. that we need to submit some sort of appointment form to them, which is something, that we haven't had to do as far as I understand it before. So I do apologize for that, ma'am. We are not aware of that. My clerk supervisor doesn't seem to be aware of that either. She wasn't informed of that. So unfortunately, ma'am, we're going to adjourn this matter to July 24th.
And Your Honor, I've explained.
Because you're here that day, counsel.
July 24th, yeah, I'm here. What time, Your Honor?
9:45.
Thank you. Your Honor, I have all the discovery. We've discussed this matter in great detail, and there'll be a resolution one way or the other as proceeding these matters on the 24th. I don't know if it's going to be a complete resolution, but at least we'll know what the next steps are to take. But I have received all the discovery, have provided Ms. Cunningham, and we have reviewed the video.
All right. Bond conditions are continued.
Thank you very much.
And we'll see that from 24th. I do apologize for that inconvenience, ma'am. All right. All right, you're all set.
Thank you.
Okay. And Mr. Lormer hasn't returned yet?
He hasn't returned. You want to put that on the record, and then I will try to call him and tell him not to come back?
Okay, that's fine. Well, no, I want to make sure that Mr. Let me just see.
No, he was here.
No, I understand that. Ms. Buckington, I need you to stop logging off and logging in because then I have to rename you all the time. So, the court's going to go on the record in the state of Michigan, Mr. Maurice Law Number 25638 in council.
Your Honor, for the record, John Goldberg, PA 30758. On behalf of Mr. Longmire. Mr. Longmire was in court, sent home to come back, not short time. I have discussed this matter with Mr. Longmire. There's been a similar to Ms. Cunningham. There was scheduling snafu from downtown, not by this court, and we're asking that this matter be adjourned to the 24th of July.
All right, the court will adjourn this to July 24th. Bond conditions are continued.
Thank you very much, Your Honor.
All right, thank you.
Thank you for your cooperation.
If you can get your, if you can just get in touch with your client, he doesn't need you.
I'm going to give him a call right now.
All right, thank you.
Thank you.
All right, the court's on the record is a matter of City of Wyandotte, Brandon Caleb, 25-4. Oh, actually, I'm sorry, I have to recall this matter. I have a couple matters from the jail that are ready. All right, we're on the record in the matters of the state of Michigan versus Jacqueline Farrell, 25557, 23245, 2476.
Your Honor, good morning. Richard T. Serrano, P33828. Your Honor, today I appear as MNDC counsel on behalf of with my client presently in custody in the Wayne County Jail. First, Your Honor, if I could address, please state your name for the record first.
Jacqueline Farrell.
All right, thank you.
Your Honor, as to the pretrial that's pending today, I informed the prosecutor that my client, Ms. Farrell, will be retaining an attorney that is presently taking care of a matter in the 36th District Court for her. So she's going to retain private counsel on that, so I'm asking for an adjournment for that reason, for that case. We are going to handle the violation of probations here.
Okay, so on the 25557 matter, you have a retained counsel?
Or
That's for the domestic violence matter.
yes, Nick Darren.
Okay, when did you retain him?
Before I was even in here, so in May.
We don't have an appearance in this file on the.
Oh, not for this, for the 36th district.
She
The third circuit court matter?
Yeah.
Right, okay, so when did you retain him on this matter?
I've been trying to get a hold of him and I've been trying to get through to him with my stepdad and I need to retain him. I haven't retained him yet.
Your Honor, we have no problem with proceeding, sorry. Unless you start generating. Yes, I understand.
Generated on, June 6th. And now this is the third time out here, I'll give you June 24th, July 24th.
Thank you.
At 10:30 a.m. Bond and conditions are continued in this matter. And so he's not representing you on the probation violations?
Correct.
I'm prepared to move forward with that today, Rob.
Okay. All right, we're on the, as to the probation violation 24716, your client's on probation for disturbing the peace, indicates, did not comply with terms and conditions of the treatment court. And, also 23245. And so, counsel?
Yes, Your Honor, once again, Richard P. Serrano, P33, treated on behalf of client in custody from jail. Your Honor, after speaking to my client regarding the nature of the allegations for violation of understands them. Honor, I've informed her about the standard of proof required for these matters being different from a regular beyond reasonable doubt standard in a criminal case. She understands that by the preponderance of the evidence.
Counsel, can you please go in the line, chair, please?
Yes, Your Honor.
Thank you.
And Your Honor, she's prepared to plead guilty as to both violations. I've advised her right to have a hearing.
All right, and we have, please raise your right hand, Jacqueline. Ms. Farrell, please, the swear from testimony about to give this matter the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. And you heard the plea that your attorney placed on the record, correct?
Yes, ma'am.
As to the allegations, how do you plead?
Guilty.
And you've gone over your advice of rights for probation violation purposes, correct?
Yes.
You understand all those rights?
Yes, Your Honor.
You also understand by entering into a plea, you'll be waiving some of those rights?
Yes, ma'am.
And you also understand possible penalty, and in this matter, recommendation is to revoke probation, close the case by and 10 days jail, and $50 probation violation fee. Do you understand that?
Yes.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Anybody promise you anything, threaten you, or coerce you in any way if you don't enter into a plea?
No.
All right, counsel, if you can please pardon your client.
Ms. Farrell, do you agree that you were placed on a period of probation on both these matters pending by this court? Agree with that?
Yeah.
Part of your
Is that yes?
I believe you said yes. Yes.
I just want to make sure for the record, because sometimes, yeah, can be misunderstood. So is that yes?
Yes, it was a yes.
All right, please answer yes or no to the judge's questions or mine. And ma'am, you agree that you were placed on probation. One of those probationary terms was that you successfully complete the Regis Wellness and Recovery program issued by the court. Is that correct?
Yes.
And during the pendency of that probation in that program, you failed to comply with all the directives that were given to you. Is that correct? As to both cases?
Correct.
Satisfied, Your Honor.
All right, the court is also satisfied because knowing voluntary is actually accurate. And in the court, we were documenting, indicate, enter plead guilty based upon enter probation violation based upon your plead guilty. And counsel has the recommendation.
Your Honor, my client remaining in custody, no objection to the recommendations.
All right, the court is going to adopt the recommendation. The court is going to order probation revoked. Case closed without improvement. However, Ms. Farrell, I will say, as I told you before, you did make significant progress in the treatment court. And you did make a lot of positive changes for yourselves and your children. So I don't want that to be turned on, okay? The court's going to adopt the recommendation, 10 days jail, road probation, and $50 probation violation fee. And we'll see you back on the 24th.
Thank you, Your Honor.
Thank you, Your Honor.
I thank you. Have a good day.
You too.
Thank you. All right. And then, all right, just, I have to read here. We're on the record in the matter of the state of Michigan versus Darren Sherman, 25369. Can you get the file for Thompson? I don't know who has it because it's the Attorney General file. And I don't know if. Let me see the plea form with that two case. All right.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of with my client, Chris Wright. This is date time set for his arraignment pretrial. Please state your name, sir.
Darren Sherman.
All right, thank you. And today is the date scheduled as counsel indicated for the arraignment pretrial. Counsel as to the arraignment.
As to arraignment, Your Honor, I've had an opportunity to speak to my client regarding the nature of the charges, all maximum penalties involved, possible consequences, be it from this court or any administrative agency. He understands all the ramifications of the charges, maximum penalties involved. Your Honor, I thereby would waive formal reading, stand mute today on all matters.
For the formal reading, enter plea not guilty for purpose of the arraignment. Yes, the pretrial.
As to pretrial, Your Honor, my client wishes to avail himself of the offer in that he will plead guilty to one of the charges, that being operating while intoxicated, and also he will plead guilty to driving while license suspended, denied, or revoked. He understands the ramifications of those two pleas. He's been advised of the rights, he's signed advice of rights. And if that plea is in fact accepted, those pleas are in fact accepted by the court, the original charge of operating while intoxicated to the point of 0.17, commonly known as super drunk, would be dismissed on the prosecutor's motion. And he's ready for the court's examination.
All right, sir, please raise your right hand. You solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, you heard the plea that you're trying to place on the record, correct?
Yes.
As to the charge of operating while intoxicated, how do you plead?
Guilty.
As to the charge of driving while license suspended, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights?
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes, ma'am.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes, ma'am.
Knowing all that, you will continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
Counsel, please run your client.
Mr. Sherman, I'm sorry, Your Honor, I didn't write the date down.
March 15th.
Thank you. Mr. Sherman, on March 15th, 2025, were you operating a motor vehicle in the city of Wyandotte?
Yes.
And at that time, prior to that time, had you been drinking alcoholic beverages?
Yes.
Tell the court, please, what you were drinking, approximately how much, and over what period of time?
Rennie.
Is that an alcoholic whiskey?
That's beverage.
Okay.
Is it what?
That's 1738 beverage liquor.
Okay. And what else, if anything?
And I was driving on my way home and got pulled over.
How much did you consume approximately?
A lot.
Okay. And you were at a wake, so to speak, a funeral?
Yes, I was leaving a repast.
Okay. All right. And so someone else was making the drinks for you?
Yes.
So you don't know how much alcohol is in them?
No, sir.
Pretty strong though, weren't they?
Yes.
All right. And then there came a time where you were stopped by the police, correct?
Correct.
Were you the driver of the vehicle, the operator of the vehicle?
Yes.
All right. And upon the police officer asking you to produce a valid Michigan operator's license, were you able to do that?
No.
Is it true that your license was suspended on that date and time? You knew that, correct?
Yes.
All right. And now, the report indicates that you were speeding quite fast in, I think it was 70 and 45. Do you agree with that? The consumption of alcohol affected you by driving that fast?
Yes.
All right. And subsequent to you being put through some field sobriety tests, but you had mixed results, You were subsequently arrested, correct?
Correct.
And were you taken to the police station?
Yes.
Did you consent voluntarily to take a breathalyzer test?
Yes.
You stipulate and agree with the results as we discussed of .292 and .296?
Yes.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charges of operating while intoxicated, driving while license suspended, high VAC dismissed per plea agreement, and counsel Esteban.
Your Honor, my client works full-time with H&H Company. He's a glazer, and he's not on probation or parole, nothing pending, Your Honor. He's here with his significant other for support. He's not driving. So, Your Honor, we'd ask the court to consider a personal bond while this is pending, but he has posted a bond in a third party's name of $500, and the bondholder is here.
Okay. And sir, if you were to test right now, what is in your system? Do you have a valid prescription?
I do, but it's expired.
Then it's not valid. So the answer to my question, do you have a valid prescription?
No.
Okay. Do you have any documentation from your treating physician that would support the need for marijuana use?
I can get that.
From a treating physician?
Yes.
All right. So, when is the last time you used any marijuana?
2 days ago.
All right, so you're not currently under the influence, are you?
No.
Okay. So, and so, how did you get here today?
My lady drove me.
Raise your hand, man.
Okay. And how did you get back and forth to work?
Ride the bike and get me.
How far do you work from where you live?
10 minutes.
All right, you live on Meadows, right?
No.
No, that's not your address.
It was, that's my old address. I don't.
Okay, just one moment.
He can write down his new.
Hubble?
Who?
Hubble?
Yes.
All right, the court is going to continue your cash finding not to possess or consume any alcohol or drugs unless prescribed, and no driving, sir. And in fact, the court is going to also order you to participate in random testing. Well, actually, I think what might be most efficient is the alcohol teller through EMS. We'll do it that way. So, sir, you're going to go over to probation. You're going to receive a copy of your bond conditions. You're going to receive information about your tether. You're also going to receive your needs assessment link, and you're going to receive your pre-sentence interview information and your dates for your pre-sentence interview and your sentencing date. Okay, so you're going to go around over to probation.
Okay.
Thank you. Have a good day.
You too.
Thank you.
And then we are on the record in the matter of the state of Michigan versus Kimberly Thompson, 25621. An appearance for the people, please.
Good morning, Your Honor. Kelly Legacy, Assistant Attorney General. P number is 66349.
Okay, I'm sorry. That's very muffled, and I have my recorder recording remotely, and I don't think that came through at all.
Okay, I apologize. Can you hear me better now?
Yes, thank you.
Okay, thank you. Good morning, Kelly Legacy, Assistant Attorney General, on behalf of the people. My P number is 66349.
All right, thank you. And counsel for Ms. Thompson. Mr. Mawad?
Sorry, Judge.
That's okay, that's all right.
Okay.
Where's your suit jacket? I thought you were getting your suit jacket on. Counsel, your suit jacket, please.
Sorry, Judge.
That's all right. Okay, your appearance, please, counsel.
Judge, on Kimberly Thompson, with the permission of the Assistant Attorney General, we had talked about waiving the preliminary exam. We think, there's an accounting issue and it's just going to have to be resolved out in circuit court.
All right, counsel, your appearance, though, for the record, please.
Elias Muad, P41632.
All right, Ms. Thompson, your name for the record, please.
Yes, Your Honor. Kimberly Thompson.
All right, and Ms. Thompson, you do understand that you do have the right to have a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge with that crime.
Yes.
And you also understand that waiving, like, upon bind over, that you will be brought over to circuit court for further proceedings on the charges and complaint warrant. Do you understand that?
Yes.
And you received notice of those charges.
Yes.
You also, has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to preliminary examination?
No.
All right, the court will note that examination having been waived, defendants brought over to circuit court for further proceedings. You are to appear in the circuit court on July 17th at 9 o'clock in the morning on the charge of the complaint warrant. And counsel, any objection, Ms. Legacy, to indicating via Zoom on the consent portion of the document?
No judge. No
I'm
objection.
sorry? No objection, okay. All right, thank you. Mr. Mawad, same question for you and your client.
No objection.
All right. Okay, the court will note bond, will order bond and conditions are continued, and good luck to you.
Okay, thank you. Kelly, I'll be in touch. Thank you. Everybody have a good weekend.
Thank you.
You as well. Okay. Is that one? Oh, sorry. Where, who, do you have the attorney for Mr. Lewis here?
Yeah.
Oh, sorry, okay. All right, and so we are on the record in the matter of the state of Michigan versus Brad Lewis. And here, well, hold on, I'm sorry, before we do that, I need the prosecutor.
Prosecutor.
Actually, no, we don't, never mind.
Never mind.
We are on the record, and we're on the record matter of the state of Michigan versus Brad Lewis, 241692, in council.
Good morning, Your Honor. Jimmy Okuda, P71963, appearing on behalf of Brad Lewis.
Okay, and Mr. Lewis, your name for the record, please.
Brad Lewis.
All right, and so council, this is the adjourn date. There's an independent competency evaluation completed, and we are awaiting the report.
Correct.
And that report has not been completed?
I haven't received anything from them.
Have you communicated with the independent evaluator?
No, I haven't, Judge. I don't know who the evaluator was. I don't know if it indicates in the court file.
Council, as an independent evaluator, from your office sought the independent evaluation based upon the report from the Center for Forensic Psychiatry.
No,
Because it
Judge,
showed that he was competent, and then the defense requested an independent competency evaluation, and there was an appointment May 20th. And then on June 12th, you substituted in, and so I'm expecting that you know who the
I'm sorry.
independent
I'll follow up with
evaluator
the
is.
previous attorney then.
Okay, no,
I'll
we're
recall
gonna-
the matter. I'll call him right now, Judge.
Yes, very good, we're going to recall him. Okay.
I'll call him now.
All right, thank you.
Sorry about that.
We are on the record in the matter of the state of Michigan versus, I'm sorry, the city of Wyandotte versus Brian Caleb, 25-4. Mr.
Mr. Smith.
Oh, does that make sense?
Yes.
Okay. Did I trust you? Is the government already? I thought I did.
Yeah, I don't know.
Okay, let me go off the record for a moment. Mr. DiMaggio, did you go in the breakout room with your client?
Well, they put me on with the wrong client.
Yes, sir.
I'm supposed to have Brandon O'Donnell.
Yes, sir. Hey, Dan.
O'Connell, right. Brandon O'Connell.
O'Connell.
Can you please read? Okay. All right, that's
Okay,
my fault.
I don't have,
Dan, do you
All right.
upload them or do
So
you
council, please
email
go back
Scott?
and break out room 3, and Mr. O'Connell, I'll put you to break out
Okay,
room
but I'm
3.
saying, whenever
Do
you,
you know if Mr. Pacheco's not checked in yet? Do we know, in person?
Yes.
Do we know if he's in person?
Okay, okay,
Or
ma'am.
he's out of custody or in custody?
Don't know that for sure, Judge.
Okay. All right,
We do have Carmen's.
okay, when you upload
Mr.
it,
Nasser.
when you upload it, do
Mr.
you upload
DiMaggio,
it to the
please
site
rejoin the
or do you
breakout
upload it
room.
to a special
Hi,
folder?
Judge.
All right, I'm just, Mr. Caleb.
Yes, ma'am.
Okay, so, yeah.
All right,
Yeah,
we
yeah, I'm
are
at the
going
green
on the
folder,
record in the
right
matter
now.
of the city of Wyandotte versus Brandon Caleb, 25-4. And today's date scheduled for the adjourned sentencing and counsel, your appearance, please, for the record.
Yes, good morning, Your Honor, and to your staff. May it please His Most Honorable Court, Mohammed Nasser, P74485, appearing on behalf of Brandon Caleb, who appears via Zoom, consents to the hearing over Zoom. Sir, please state your full name for this honorable court.
Brandon Caleb.
All right, very good, thank you. And I apologize for the delay today. And this matter was adjourned as the court did not have the documents timely that defense wanted the court to take into consideration in imposing sentence on Mr. Caleb for the charge of disorderly conduct. The assault, battery, and open alcohol had been dismissed. And counsel, did you have an opportunity to review the report and recommendation with your client?
We did, Judge.
Are there any corrections that need to be made?
Not any additions, deletions, or corrections, but I'll elocute if this court will allow.
Yes, counsel, you may proceed.
Judge, first and foremost, we want to thank this court. I know that we submitted documentation late. So I'm thankful that this court allowed us to continue so this court has an ample opportunity to review. As this court is aware, this was a plea agreement that was ultimately worked out under 771.1. The PSIR indicates a request the court or their recommendation says not to give 771.1 based upon previous HIDAs. As this court is aware, there is no limit on HIDAs and there's no limits on 771.1. It's within this fine court's discretion. Now, my client is 25 years of age. He's gainfully employed, has his own business. We've also included the certificates of anger management and the like that has been forwarded to this honorable court. At the end of the day, Judge, undeniably, statutes such as HIDA and 771.1 are designed to address young individuals and most aptly young adolescent males. There's a Michigan Supreme Court case and, of course, medical documentation that suggests that a young adolescent's mind doesn't even fully develop till the age of 25. With that being said, Judge, there was a resolution and a sentencing agreement, for lack of better terms, allowing or suggesting 771.1. What we're prayerful for, Judge, is that you follow the original agreement between ourselves and the prosecutor. I'm confident Mr. Caleb will prove himself worthy to you. And if this court is so inclined, you can keep it on a tight leash. You can have a review period. But I'm confident this young man has turned his course, understands and appreciates the significance of the reduction that he received here. But most importantly, Judge, this is a young man that has a lot on his plate. He's got a business and he's got goals to proceed in life. And he understands that being in courts as a defendant is certainly not something that will, be in conjunction with an individual that's successful. So I'm prayerful that this court will honor the sentencing agreement or the sentencing as listed under 771.1. Give this young man a chance to prove himself, Judge. He's here. He's always been here. He presents himself well in court. But what I've seen from Mr. Caleb, most importantly, is a desire to move beyond this particular incident and to ensure that he has taken the remedial steps necessary via classes to ensure that impulse control and anger management is no longer a issue. So he has the tools necessary to avoid these type of instances. He's done well on bond, and I'm prayerful this court will give him that chance.
Okay, well, thank you for that. And the court will note that the agreement that council had between themselves, the court also made clear on the record that the 771, as well as the 6 to 12 month probation, were recommendations only. And that that the court does not have to follow that recommendation. So let me ask this question. Sir, are you out on bond in any other jurisdiction?
No, ma'am.
All right, counsel, the attachment from the 14A1 district court, that was supportive. That was to support your request for an adjournment, correct?
That is correct, Judge, yes.
Okay.
My apologies.
No, that's okay. I just wanted to make sure that I wasn't misreading something.
No, not at all, Judge.
So, the purpose of probation is to allow individuals an opportunity to correct behavior and to learn from their mistakes, because everybody makes mistakes. The court also will note that the purpose of HIDA is to allow individuals an opportunity to further have that mistake removed from their record, as well as 771.1 status. And while there's not a limit as to how many there can be, it clearly is in the court's discretion, as counsel indicated, as to whether or not the court will allow an individual to have that opportunity again. Now, the charges in this matter were assault, battery, disorderly conduct, and open alcohol. Mr. Caleb has had 2 matters dismissed for HIDA 8 years ago, and further had an open alcohol dismissed pursuant to 771.1 status in this court 2 years ago. So, I have serious concerns that Mr. Caleb is not taking these opportunities as he should, and modifying his behavior.
Judge, may it please the court?
Yes, counsel.
Judge, I certainly agree with the sentence of the court. We're talking about a young man that's 25 years of age now. 8 years ago would have made him about 17, and 2 years ago would have made him about 22 or 23. The difference now and 2 years ago, Judge, is that he's taken remedial steps, as in courses. Simply, and Judge, having the opportunity to practice for some 14 years now, a lot of times I stand before the court and I indicate, hey, listen, this individual has done a 180 and he has changed. However, a lot of that happens without any proof. In this instance here, he's found solace in taking courses, and more importantly, Judge, the rubber has hit the road. He understands that if this court is kind enough to give him one final chance after 771.1, that is not going to happen again. Mr. Caleb understands that, Judge. He's had an opportunity largely to really mentor with Edward Martell. And as this court is aware, Mr. Martell is an individual that was on the other side of the law, that he had some 19 convictions. And at some period of time, he stood before a judge, much like yourself, and made a promise to the judge that he would change. And he did. And he is now a licensed attorney. And I say that to say that many times people need some type of guidance and a mentor to look at someone who has been on the other side. I believe Caleb has done that, and he's been given benefits, Judge. He has. He has no felony convictions. However, what he does have is a plan, and he has the treatment, and his desire is not to stop with just the simple classes that he's taken. His desire is to continue seeking the embetterment, working with Mr. Martell, and having that ideology in his head so he can understand that, you know, criminality only leads to two things: a record, jail, prison. And that's not something that Mr. Caleb wants. So I am prayerful that this court will give this individual one last chance based upon, his counseling, the certificates provided, but more importantly, his working with Attorney Martell, someone who has been on that other side. And we find our job as attorney and counselors. And I think that counseling position reads a little bit differently. I can say the same thing to Mr. Caleb. However, understanding that I've never been on the other side, sometimes people see it as I don't understand, even though I've been there for 14 years. However, someone like Mr. Martell, working as closely as he has with Mr. Caleb, I think has had I'm confident, has had a positive influence. And I'm prayerful, Judge. Give him one chance, put him on a tight leash. If he violates in any way, he understands and appreciates that he can go to jail. So I'm asking you to give him a chance under 771.1. And if we violate, certainly the court record will reflect that we understand that we are facing jail, and Mr. Caleb accepts that challenge because he's not going to be doing anything else awry. Is that correct, Mr. Caleb?
Yes, sir.
Well, okay, and counsel, I can appreciate all of that, I really can. But this all appears to have started over two different vehicles backing out of parking spots. And it resulted in an altercation. And it resulted in your client being charged with assault and battery, disorderly conduct, and open alcohol. So, and for some reason, Mr. Miller and Mr. Parsons have not, whether they were contacted, not contacted by the prosecutor, I'm not sure. I know they were sent communication regarding today's date. Is Mr. Miller and Mr. Parsons present? No, and they've not checked in. However, the concern this court has is that this incident, you're here from what started as two vehicles backing out of a parking spot at the same time. And it escalated to the point that you are here now, sir, charged. You were charged with 3 crimes, you pled to 1. Let me tell you, there are many times people get frustrated in the parking lot, sir, by behavior of people. That doesn't land them in court.
Yes, ma'am.
And I'm not really sure how many opportunities you believe you're afforded before you change your behavior. Because you have an assaultive history. And I can appreciate that you've taken an anger management class, but sir, I think that you need a little bit more than a 1-day or a 4-hour anger management class.
Question, ma'am.
How long was your anger management class, sir, that you completed online?
4 hours, but I also have a question. You said prior like assault or something? You just said prior like assault or something?
I just said you have an assaultive history, and that's just based on some of the other matters that have been dismissed. I didn't want to go into details of those. Just the nature of the charges on that, which I understand have ultimately been dismissed. But the fact is that you've been charged with those matters. You've been processed through the criminal justice process, and that is why I made that statement, sir.
Okay, yes, ma'am.
And sorry, Judge, we didn't mean to interrupt. Forgive us.
No, that's fine. Quite frankly, sir, your attorney worked out an extremely generous deal for you, given the allegations that occurred.
Yes, ma'am.
So tell me something you learned from your 4-hour anger management class.
So it went over, so one thing, it gave me a lot of techniques on like how to control my anger. So one that really stuck with me was, it's called the 10-second rule. And basically like before making an emotional decision, like you count to 10 in your head and just think everything through before you make that emotional decision. That was one of the things that I learned. Yeah, just like basically how to control your anger and everything. It gave me different types of techniques. That was the one that stuck with me the most, but
Okay. Sir, let me ask this question also. If somebody else is trying to pull out of a parking spot at the same time, does it really matter who's pulling out first?
No, ma'am.
So then, I would hope, in the event you're in another parking lot and another driver frustrates you, or you're driving on the road and you have somebody frustrate you, because that happens on a daily basis for everybody, right?
Yes, ma'am.
Just let it go.
Absolutely.
Let it go. It serves no purpose.
It's not worth it.
Just to be the first one out of the parking spot.
Yes, ma'am.
It serves no purpose. If you think somebody's being an arrogant jerk to try to confront them and change their behavior. Here's what the court is going to do, Mr. Caleb. The court is going to give you one final opportunity, and let me be very clear when I tell you it's one final opportunity.
I hear you.
If there is the slightest violation, that 771 status will be revoked.
Yes, ma'am.
So perhaps you can work on your 10-second rule right now, because I'm sure what I'm going to say is frustrating to you. So 12 months probation. Well, actually, the court's going to order that, indicate that after hearing from Mr. Nasser, hearing from Mr. Caleb, reviewing the report, the recommendation, the court does find there's reasonable grounds for pardon MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable proportionate to the seriousness of the matter and the circumstances surrounding Mr. Caleb in light of the legislative guidelines. The court's going to order 15 months probation. You're eligible for early discharge. You're also eligible for 771.1 status. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You're to notify your probation officer immediately when you change an address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition, sir, so the court can monitor your progress in maintaining absence and sobriety. You'll have to participate and complete the Alcohol Awareness PERS 2 class. The rehabilitative goal for that condition is to further teach you regarding alcohol use to make so you can make better informed decisions in the future. You're not to have any contact with Tyler Miller or Jacob Parsons. That's phone contact, text message, email, social media, third party, anything of the like. You are not to possess any weapons or firearms. Do you have any of those, sir?
Yeah, but you told me I had to give them to a third party, so I don't have possession of them no more.
Okay, that's going to continue until you're off probation. You
Yes,
are
ma'am.
to participate in an 8-week anger management class. I understand and can appreciate you completed 4 hours, but the court's going to have you participate in an 8-week anger management class.
Yes, ma'am.
Your goal for that condition is to allow you to further understand how to properly express your feelings and needs when you are in an emotionally upsetting situation. I'm not diminishing what you've already taken in, sir, but I think there is a bit more work that needs to be done to
Absolutely, yes, ma'am.
completely modify that issue. No contact, let's see, I did all that, and there's $0 in restitution that's been requested. Any questions regarding the conditions?
No, ma'am.
And I will note that the court ordered 15 months probation because I don't want you rushing through all of those conditions, sir. I want you to be present with each of them, not just rush through to check off a list.
Yes, ma'am.
The court's going to order a $500 fine, $100 screening assessment fee, $450, right. $750 supervision oversight fee, that's 15 months at $50 a month, and since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee is $75. Justice system assessment fee of $50. for a total of $1,775. You did post a bond of $500. Do you have any other money you intend on paying today?
Do I have to be like, do I have to come up there today to pay? That'd be the only way is like if I came up there, but I have to go to work after this, so it'd be kind of hard to get there today.
You can pay it online, sir.
Okay, yeah, I can do that.
How much you pay today?
Can we do like 150?
Okay, so a total of $650 will be paid today when we apply your bond as well. And then on the balance of $1,125, how much can you pay per month and what day of the month works best for you, sir?
I'd prefer somewhere in the middle of the month, and can we do 150 also? And if I can make a bigger payment, I can do that.
Yes, beginning August 15th.
Oh, that's perfect.
And the court, I'm sorry, the court's going to also order mandatory revocation of under advisement status for any violation. I know I stated that previously, but I didn't indicate that in my order. All right, any questions?
No, I think that should be it for me.
All right, as the court did indicate, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation conditions have been completed. You've had at least 3 months without any violations, and all money has been either paid in full or you've made a good faith effort to making full payment. And just for the record, counsel, I did review the exhibit list in support of sentencing for your client and the letters that accompany that, okay? I just wanted to let you know that I did.
I think my attorney just left the chat.
Well, I don't know where he went. But, okay, so email into probation by 12:15.
Could you repeat that for me? Sorry.
Please email into probation by 12:15.
Okay.
All right, thank you. All right. I'm not sure, there's Mr. Nasser. Hold on, sir, your attorney just logged back in. Okay, Mr. Nasser, I'm not sure at what point you left, but I did tell your client regarding the early discharge, and we do have a payment plan set up, and I did instruct him to email into probation by 12:15.
Thank you so much, Judge. Always a pleasure.
All right, have a good day.
Thank you, Judge.
Thank you. All right, Justin Carlton, 24416.
Ready? Your Honor, good morning. Richard T. Serrano, T2328. Today, Your Honor, I appear as MNDC counsel on behalf of my client, Mr. Carlton, who's presently housed in Wayne County Jail. And this is the date and time set for his violation of probation allegations. Sir, please state your name.
I need you to unmute, Mr. Carlton.
Justin Carlton.
All right, today's date scheduled for probation violation. Counsel, as you indicated, your client was arraigned on his probation violation hearing on Monday, July 1st. No, it'll be Tuesday, July 1st. It failed to appear for his probation instruction on 2 times. One had been rescheduled, given the benefit of the doubt, and then he didn't appear, so we set today for probation violation. Counsel?
Your Honor, after speaking to my client, he understands the allegations, he understands the standard of proof requisite if he were to elect to have a violation of probation hearing. He's been given all his rights regarding that. He chooses to plead today, Your Honor, to plead guilty as charged in the violation of his probation.
No. Okay, Mr. Carlton, please raise your right hand. Do you solemnly swear from the testimony about to give this man to be the truth, the whole truth, and nothing but the truth?
I do, yes.
All right, and you heard the allegations, correct?
Yes.
And as to the allegation, you failed to appear for your probation instruction twice. How do you plead?
Guilty.
And you've gone over your advice and rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court. You understand that?
Yes, I do.
And that the recommendation in this matter is to revoke probation, close the case without improvement, $50 probation violation fee, 90 days jail. Do you understand that?
I understand.
All right, and knowing all that, do you want to continue with your plea?
No.
Knowing all
That
that,
would be the recommendation.
that's the recommendation. The court got that recommendation in full, in part, or not at all. So knowing all that, do you want to continue with your plea?
Am I allowed to say anything now?
In just one moment, you may, yes.
Answer that question, sir.
Do you want to continue with your plea?
Yes, I understand.
Okay. And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, they haven't.
All right, Counselor, you can please mark your client.
Mr. Carlton, can you hear me?
Yes, I can.
Do you acknowledge that you were placed on a period of reporting probation with this court, 27th District Court, in this matter?
Yes.
You were, part of your obligations were to appear as directed, correct?
Yes.
There are two separate occasions, one being July 16th, and I'm sorry, Your Honor, what was the other date?
August 21st.
Thank you. August 21st and July 16th, 2024, you did not appear. You agree with that?
Yes.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation and indicate technical violations 1 and 2 will enter. And, counsel?
Your Honor, my client in custody today, he expressed over and over to me that he's a single father. He supports 2 minor children, ages 2 and 7. He has no idea who's taking care of them right now. Your Honor, we would ask the court to consider. He said he can post the $350 bond that this court initially set through at 3,510%. He can take every effort to post that. He believes he will be able to. If he posts that bond, Your Honor, we're asking the court to defer that 90-day jail sentence if it's going to adopt it, or give him some time to be released to take care of his children after posting of the bond, and then we'll do what the court deems fit.
Well, okay, sir, how were you brought into court? How were you brought into custody?
I was sitting in a CVS parking lot, in the passenger seat of my girlfriend's car, and
That's right. That's right. And so where were your children at that time?
they were at our friend's house.
Okay, well, presumably they're still with that friend. But you left them with somebody when you left and went to meet up in the CVS parking lot.
Well,
What's that, sir?
You're right. I mean, we were gonna pick them. We were picking them back up. I was staying at the friend's house that night.
Right. And, yes, and sir, here's the thing, right? You were given an opportunity for probation, sir, and you did not show up for your first probation appointment. It was rescheduled. And then you didn't show up again, and you haven't done anything to take care of it. And what's happening with the matter? 12 months probation. You must have just gotten off probation on your other matter that was here, correct? Oh, no, I'm sorry. Never mind. That's this one. So my point is, sir, is that in this matter, this was a felony matter that was charged, and ultimately you pled guilty to a misdemeanor. And you have that benefit of the doubt in you, or that benefit and that opportunity. And the court also ordered, at the time of sentencing, the mandatory jail for any probation violation and clear up your warrant.
If I don't get out, I'm gonna lose my children. I'm going to lose them. Now, if I can get out, I guarantee, I promise you, with everything in me, I cannot lose my children, Your Honor.
Sir,
Yes.
sir, do not put that on the court. Your actions are why you are in that situation, not the court.
Hey, you're right. You're right.
You should have taken care of your responsibilities back in the summer. when you were given an opportunity and you didn't, and you went almost an entire year before you ended up coming in before the court, and that wasn't because you voluntarily walked in, you were arrested. And you don't live far, you live the next town over. You live literally a mile and a half from the court. The court's going to order 45 days jail, credit for 3 days, revoke probation, close case.
You still have obligations to the fines and costs?
Yes, he does. Good luck to you, sir.
Thank you, Your Honor.
All right, we are on the record in the matter of the state of Michigan was Robert Pacheco, 25908. Is he in custody?
Good morning, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
Okay, we're going to recall this matter.
Lewis. Yeah.
Okay, Mr. let's go off the record. Mr. DiMaggio, are you ready on your matter? Have you spoken to the prosecutor?
I haven't spoken to the prosecutor, but I did interview the Mr. O'Connell.
You've not spoken with the prosecutor?
No.
Okay, I thought I saw you in there previously. Your name in there. Let me move you over there, sir.
Thank you, Judge.
Okay, so we're on the record in the matter, well, actually, where's Mr. Serrano with the 915 ones? Do we have to done on those, you know? Okay.
Cagle.
Yes, Cagle and, Yenna. And Foley?
Foley's finished up here.
Okay.
I will check who's checked in.
Okay. All right, let's go on the record in the matter of the state of Michigan versus Morris Fletcher, 25601.
Good afternoon, Your Honor. Brian Kelly on behalf of Mr. Fletcher.
Good morning. Well, it's been a while since I've seen you.
Yes,
We
it
had a
has.
piece together years ago.
Yes, yeah, right when you were, I think, originally running.
I think so, yes. Okay, good to see you, counsel. All right, insert your name for the record, please.
Morris Fletcher.
All right, and today's date scheduled for the arraignment pretrial in this matter, and counsel asks for the arraignment.
I'll stand mute, wait formal reading, Your Honor.
All right, the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment, and as to the pretrial, counsel.
Your Honor, I've had an opportunity to speak with the prosecutor. We're making really good headway on the matter. We're asking for a slight adjournment so I can get some additional information over to their office.
All right, does July 31st work?
What time, Your Honor?
What time works for you?
Morning, please, Your Honor. That should work, yes.
We can do.
Could you like a 10 a.m.?
I was just going to say we can do 10 a.m.
Thank you.
All right, and as to bond.
And I believe is it a PR bond that was issued by the officer, if that's what it is?
No, your client, had posted a bond, but, as to, what I should know before I assess any conditions.
Your Honor, my client's been a manager for Ford for quite some time. Because of the incident, he's actually currently looking for new employment. He's got a job interview today. He has not had any encounter with law enforcement or any issues, I don't think ever in his life. This is his first encounter with the system. We'd ask that you take that into consideration.
All right, sir, if you were to test right now, what is in your system?
Okay.
Have you ever failed to appear in court for any reason? Are you on bond in any jurisdiction? Other than this one?
Other than
And when's the last time you consumed any alcohol, sir?
April 26th.
Okay. All right, the court's going to, order the cash bond to continue. You're not to possess or consume any alcohol or drugs unless prescribed. And then we'll see you back on July 31st. Just have a seat and get a copy of your bond conditions, okay?
Thank you, Your Honor.
Thank you. Have a good day.
You too. It's good seeing you.
You as well. And we are on the record the matter of the state of Michigan versus Jason Trueblood, 25368.
Good morning, Your Honor. Attorney Maxwell Duke, P number 86012, on behalf of Mr. Trueblood, who stands to my right.
Good morning. And, sir, your name for the record, please.
Jason Trueblood, Your Honor.
All right, thank you. And as to today's the date scheduled for the arraignment pretrial in this matter, counsel as to the arraignment.
My client will waive formal reading of the arraignment, stand with you, Your Honor.
All right, for waiver formal reading, enter plea not guilty for purposes of the arraignment. And then as to the pretrial, counsel.
Your Honor, we were asking for a brief adjournment in this matter. I believe I put 3 weeks on there. We do have a tentative resolution in place. That being said, I do believe I want to explore sobriety court options with my client and further solidify that resolution. For those reasons, I think 3 weeks should be enough. Client is a resident of Wayne County, Lincoln Park specifically, so I'd like to look into their sobriety court if you are willing to permit me time to do so.
Okay.
My foot is fully asleep right now, so.
Your foot is fully asleep?
Oh, yeah, I'm trying to.
Right.
I let me saw me stumble when I walked over here. It's dead.
10:45 on the 24th.
10:45 on the 24th.
And then as to bond counsel.
Your Honor, aside from the obvious previous DUI, seeing how this is charged as a second, my client has a very clean criminal history. He's been very responsible since. Contacting my office, he's been in constant communication with me. He does not have a history of skipping court. He doesn't have a history of violating bond, Your Honor. Additionally, he doesn't have any violent crimes. For all those reasons, I don't believe my client to be a flight risk nor a danger to the community. Again, he's been in constant contact and working very closely with me. I would ask for a personal bond for all of those reasons.
Okay. And sir, if you're to test right now, what is in your system?
Nothing, Your Honor.
Have you ever failed to appear in court for any reason?
No, I have not, Your Honor.
Are you currently on probation or parole anywhere?
No, Your Honor.
Are you out on bond in any other jurisdiction?
No, Your Honor.
All right, so what happened with your matter in June in the 33rd District Court? Did you had fines and costs only?
Yes, Your Honor, as well as our probation that's been finished with by now.
Okay. And when did your probation complete?
He got off at the halfway mark, and I believe he got 12 months, and then he got off in 6. Is that correct?
I had gotten, I believe, 5 to 10 months, and I was off in about 5 or 6.
Okay, so by December you would have been off, and now then you were arrested again in March.
I was off starting the beginning of February, and then yes, the rest of the
Oh, so less than a month.
Yes, Your Honor.
Okay.
That's why we were pursuing sobriety.
Good pursuit.
Thank you.
And given the level that's alleged as well. So, all right. And what the court's going to do is the court's going to order you not to possess or consume any alcohol or drugs that are not prescribed. The court will continue your cash bond, and the court's going to order you to participate in random testing. So you're going to have a seat, you're going to get a copy of your bond conditions, and then you're going to go over to probation, and you can be set up with random testing. So you live in Lincoln Park, so you can likely test it on site, which is in Lincoln Park, so you can just communicate that with them, okay?
Yes, sir.
I apologize so much, Ryan. You said July 24th?
At 10:45.
July 24th, 10:45. Thank you so much. And great to see you as always, and I wish you guys a very happy 4th of July, since I probably won't see you since.
Okay.
But I'll probably see you next week, so.
No, you won't see me next week, you'll see a visiting judge next week.
Where you going?
On vacation.
Oh, lucky you.
Yeah.
Thank you, Your
Some
Honor.
time off, okay. All right, have a good day. Okay, so off the record, Mr. Pacheco.
Oh, cool, yeah.
Oh, thank you. Oh, thank you. Mr. Pacheco. I know, Mr. Pacheco.
Yes, ma'am. Hi, Your Honor.
Sir, you're a little late zooming into court.
I'm so sorry. I got the wrong date.
All right, you have to,
Work
you're saying you're at work, sir, but you're gonna have to remove that hard hat, you're gonna have to go to a spot that you can safely remove that. Now put you in a breakout room with your attorney.
Sorry, can you say it again?
I'm going to put you in a breakout room with your attorney, and then you have to make sure you're in a spot that you can safely remove your hard hat.
Yes, ma'am. Thank you.
Thank you. Okay, I don't know if this,
Cable, yeah, or FTs.
oh, they're on, please, okay, thank you. All right, and so we are on the record in the matter of the state of Michigan versus Brandon O'Connell, 25866. And Mr. DiMaggio, your name for your appearance, please, for the record.
Good morning, Your Honor. Andrew DiMaggio, P45619, on behalf of Brandon O'Connell.
Thank you, sir. Please unmute and state your name for the record.
Brandon O'Connell.
All right, thank you. And so today's meeting scheduled for the public health conference in this matter in the council.
I couldn't hear that, Judge.
Today is the date scheduled for the probable cause conference. And
Yes, I've talked.
And what's happening today, council?
My client explained the nature and purposes of an exam. He wishes to waive the exam.
All right, and Mr. O'Connell, you heard what your attorney indicated, correct?
Yes, Your Honor.
And you understand that you do have the right to have a preliminary examination where it must be shown that their crime was committed, the probable cause exists to charge you with that crime. Do you understand that?
Yes, Your Honor.
And you understand that by waiving your right to the examination, you will be bound to the court
Yes, Your Honor.
for further proceedings on the charges in the claim warrant. And you've received notice of those charges, correct?
Yes, Your Honor.
Has anybody promised you anything about you look forward to anyway, you waive your right to a preliminary examination?
No, Your Honor.
All right, the court will note examination given by waived, defendant found over circuit court for further proceedings, you are to approve circuit court on July 10th at 9 o'clock in the morning. Also, do you have any objection to the court indicating via Zoom on both your signature line and your client's signature line?
No objection, Your Honor.
All right. And the court will note bond conditions are continued. And good luck to you both.
Thank you, Judge.
Have a good day.
Judge, is there a Ronald Johnson on the docket? They told me I was spot appointed.
I'm sorry, just a moment, let me go off the record. Okay, what is that, counsel?
Is there a Ronald Johnson on the docket?
Ronald Johnson. Do you have a Ronald Johnson on the file?
No.
We don't have a Ronald Johnson on the file or on the docket.
Okay, they must have given me wrong information. Thank you, Judge. Have a nice holiday.
Thank you. Okay. And we are on the record in the matter of the state of Michigan versus Nicholas Bonnet, 25206.
Good morning, Your Honor. Greg Bullahanis, P36431, on behalf of Nicholas Bonet.
Bonet, okay, I'm sorry. And sir, your name for the record, please.
Nicholas Bonet.
Okay. And so today is the date scheduled for the arraignment pretrial of this matter, and counsel asks to the arraignment.
Waive the formal reading, my client stands mute. We'd ask the court to enter a not guilty plea for purposes of arraignment.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment, and ask to the pretrial.
We resolve this matter, Your Honor. The prosecutor is moving to dismiss the original charge in exchange for my client pleading guilty to OWI. And we're ready, after the court reviewers my client regarding his rights, we're ready to put on the proofs.
All right, thank you. Sir, please keep your hands out of your pockets. Please raise your right hand. Do solemnly swear or affirm the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right. And sir, you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the amended charge of operating while intoxicated first offense, how do you plead?
I plead guilty, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Not at all, Your Honor.
All right, and counsel, if you can please, I'm sorry, any immigration issues?
No.
If you can please order your client.
Yes, sir. Mr. Bonet, I'm going to direct your attention to February 15, 2025. Were you operating a vehicle in the city of Wyandotte on that day?
Yes, I was.
And prior to operating the vehicle, did you consume alcohol?
I did consume alcohol that day.
And do you recall approximately how much and what type of alcohol you consumed?
I believe I was drinking Guinness. I had about 5, 6 of them.
Okay. And what caught the officer's attention regarding your driving was that you were speeding, correct?
That is correct.
And in part was the speeding, did the alcohol contribute to the speeding? Correct?
I believe so, yes.
Okay. And do you have any, you stipulate that that you did take a Intoxication 9000 breath test and the results were 0.08 or more, correct?
That is correct.
I'm satisfied, Your Honor.
All right, thank you. The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And counsel asks to bond.
Your Honor, I do have a document here. Mr. Bonet has been engaged in substance abuse counseling.
May
I approach?
Yes, take over that for you. Gordy, I didn't see you right here.
Yes, ma'am.
All right, no, sorry, counsel, you may proceed.
My client has been proceeding with a psychiatrist, and they have been, if you read through the paperwork, Your Honor, they've been working on, he has some other issues regarding ADD, but in addition to that, they've been working on prevention, relapse, and so forth. And so, do you recall approximately what date you started doing the counseling, sir?
After the incident, Your Honor, I immediately went to the guidance center, and I believe it would have been the next week. It would have been.
So shortly after the incident, about a week or so, Your Honor, he immediately started being proactive in this matter and taking responsibility by doing the counseling. And in addition to that, Your Honor, I just wanted to advise the court, we intend to explore the issue of sobriety court with the 23rd District Court. So we'll, as soon as we do this plea, we'll contact them immediately and get them the appropriate information to potentially transfer the matter.
Okay. And also reviewing this as well, we have the treatment court here that your client might be eligible for as well, based upon some of the.
I don't want him to do 2 treatment courts, Your Honor.
No, I'm not saying
Oh.
2, I'm saying instead of the 23rd, based upon some of the mental health issues, then he could be eligible here for this court.
I
as
understand.
well. And that also allows it's the same benefit for the licensing, just so you know.
I understand.
It's not strictly the sobriety courts for that.
Yeah, I think the primary issue is the alcohol.
Okay,
And
I'm just
so- and
indicating,
that's the
if your client's interested, I mean.
I'll advise
you
him
know.
of the
Yes.
mental health court as well.
All right, and so, sir, how have you been feeling?
I've been doing my best to stay sober, and I'm feeling good about being sober.
Okay, and if you're to test right now, sir, what is in your system?
Somebody recommended I try marijuana for sleep like a week and a half ago, but it's not for me. It could be in there, but it's not my thing.
All right, well, moving forward, the court's going to order not to possess or consume any alcohol or drugs unless prescribed. Where is it you're working, sir?
Oh, I'm actually a residential plumber. I do service calls and consultations, things like that for a small LLC.
Okay. All right, and so the court's going to order you to participate in random testing, and we're going to continue your cash bond. So I'm going to have you go over to probation. You're going to receive a few things. You're going to receive a copy of your bond conditions. You're going to receive the, you're going to make sure you give them your email address so you can receive the link for the needs assessment. You're going to receive pre-sentence interview information. You're also going to, who's ever trying to share, stop your screen sharing. You're also going to get your PSI information and your PSI date and as well as your sentencing date, okay? So it helps, you can work with your schedule as well on that one.
Yeah, I'll talk to him about how that, and I always indicate to the client what they need to do and everything. And plus with the transfer of the potential sobriety court as well.
Okay, all right, thank you. Okay, so, okay, give me just one moment, I just have to step off the restroom, I'll be right back. There are 2 other matters.
Do you want him to wait?
No, he'll work.
Just, he'll get his probation, okay. Everyone please rise.
We're not needed, so if anybody's talking, we're not.
Everyone please rise. 27th District Court is back in session. Honorable Elizabeth DeSanto presiding. You may be seated.
All right, thank you. All right. Okay, and so, Mr. Carmen, we are going on the record in the matter of the state of Michigan versus Robert Pacheco, 25908. And appearance, counsel?
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
All right. Please start your camera. Thank you. All right, Mr. Pacheco? Your name for the record, please.
Robert Pacheco.
Okay, and today is the date scheduled for the probable cause conference. And Mr. Pacheco, Mr. Carmen?
Your Honor, I spoke with the prosecutor on this. I was actually just appointed on this matter about 2 hours ago. The county actually sent me a text asking if I could take it. I said yes. So I spoke with the prosecutor. He sent me discovery a little bit ago, but I'm just asking for a 2-week adjournment so I can have some time to review it, review the law, and speak more with my client to take a course of action.
All right, does July 24th work, counsel? I know that's not 2 weeks, it's 3 weeks, but does that work for you?
Yes, that's fine, Your Honor. Thank you.
All right, at 10:30 a.m.?
Could we set it closer to 9?
Okay. And also, if you can please go over time, I'm presuming you're waiving time for your client?
I'm sorry?
I presume you're waiving time for your client. Can you please go over that with your client, please, on the record?
Yeah, Mr. Pacheco. So you'd be available at 9 o'clock for the next hearing, correct?
No, counsel, the time, the 14 days?
Oh, yeah, I'm sorry. Yeah, Mr. Pacheco, you have the right to schedule a preliminary exam 14 days from today. But we're going to go out 3 weeks. So are you okay with waiving that right so that I can take some time to review the discovery and we can speak further?
Yes, I am.
All right, all right, and so the court will note that time is waived on the record. Bond and conditions are continued. We'll see you back on July 24th, 9 a.m. Sir, make sure you have the date in your
23rd?
July 24th at 9 a.m. And
24th.
also you have your client's contact information, correct?
Your Honor, I don't have it from the county yet.
No, did you get it from your client while you were speaking with them in a breakout room?
No, I did not yet.
I'll put the two of you back in a breakout room so you can have that information. Let's go off the record. This will be breakout room 3. Let's go on the record in the matter of the City of Riverview versus Katira Jackson, 25463.
Ready. Good morning, Your Honor. Greg Bulahanis on behalf of Katara Jackson. Who stands to my left?
All right, thank you. And ma'am, your name for the record, please.
Katara Jackson.
Okay, thank you. And today is the date scheduled for sentencing on your client's plea to an amended charge of operating while visibly impaired by alcohol. And the original charge of operating while intoxicated was dismissed. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. No additions, corrections, or deletions. We'd ask the court to adopt the recommendation as is indicated in the report. She is doing substance abuse counseling, and the recommendation is that she continue that substance abuse counseling. And obviously she wants to continue that. I think it's reasonable under the circumstances based on the facts in this case. The recommendation. We'd ask the court to adopt it.
All right, and so ma'am, if you were to test today, what is in your system?
Nothing.
And how have you been feeling since you have been participating with your treatment?
I feel okay.
All right. All right, and so the court will note, after hearing from counsel, hearing from Ms. Jackson, reviewing the report, the recommendation that there's reasonable grounds to depart from MCL 769.5. The court will also note that the following sentence is reasonable and proportionate to the seriousness of the matter, also in the best interest of justice. The court will also note that the circumstances regarding Ms. Jackson and legislative guidelines are also taken into consideration. The court will order 12 months probation. You're eligible for early discharge. I'll go over that in just a short bit. You are not to violate any criminal law or need of government. You're not to plead the state up in the front of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition, ma'am, is so the court can continue to monitor your progress in maintaining the abstinence of sobriety. The court will also order you to continue with your outpatient substance use counseling. The rehabilitative goal for that condition is to continue to provide you with coping mechanisms so you may maintain sobriety and prevent relapse. And the court's going to also order you to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and to educate about the consequences of such behavior. Do you have any questions regarding any of that?
No, Your Honor.
All right, the court's going to order the following fines and costs: $300 fine, $100 screening assessment fee, $600 supervision oversight fee, that's $50 a month at 18 months, and since you're, 12 months, and since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, assistant assessment fee of $50, for a total of $1,425. Do you have any of that to pay today? Ma'am, how much of that do you have to pay today?
She's asking for a payment plan, Your Honor, of $200 a month, starting August 1st.
Okay, this has been pending since March. You don't have anything to pay today, ma'am?
I I can pay $100 today.
Okay, so we can do $100 a month, $100 per month beginning today. If you can pay more, you can pay more. Okay? So if you can pay more, you can pay more, but I'm just going to order at a minimum $100 per month beginning today, okay? And the court will also state, as I previously stated, ma'am, that you are eligible for early discharge as long as all the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment, okay? All right, good luck to you, ma'am. Please stop over probation. Somebody will be with you shortly, okay? Thank you. Have a good day.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?